Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-5122 et al. Climate United Fund et al. Versus Citibank NA, Environmental Protection Agency, and Liam Zeldin in his official capacity as Administrator, United States Environmental Protection Agency, appellant. Mr. Roth for the EPA, Mr. Allen for Citibank NA, Mr. Unikovsky for the private grantees, Ms. Kim for the state banks.
Good morning, Council. Mr. Roth, please proceed when you're ready.
Please support and Roth on behalf of the company. Your Honors, the district court here enjoined termination of plaintiff's grants. The question on appeal is whether that was proper. It was not. Plaintiff's APA claims were precluded by the Tucker Act, and what plaintiffs call their separation of powers claims fail on the merits and couldn't justify this injunction anyway. Now, after NIH in California, plaintiffs don't really want to talk about the termination of their grants. Instead, they want to talk about who owns the funds in the Citibank accounts. That is jumping ahead. Due to challenge the termination of their grants, that was the final agency action they sought to set aside. The district court enjoined the termination and revived the contractual relationship between EPA and the grantees. That's the only issue that is before the court right now. If plaintiffs want to argue that regardless of the termination of their grants, they get to keep the money in the Citibank accounts, I think that's an utterly implausible position, but it's not the issue that was decided below, and it's not the issue that is teed up for this court to resolve. The only question here is whether the district court erred by enjoining the terminations and reinstating the grants. And as to that, we think the district court clearly did err, and I'd like to walk through each of the claims that plaintiffs have pressed to explain why each of them is either jurisdictionally flawed or legally flawed or factually flawed. First, the district court's principal basis for its injunction was its conclusion that the terminations were contrary to the terms and conditions of the grant award. The grant awards include a termination clause, and the district court said EPA hadn't shown that the conditions for termination were satisfied. That is literally a breach of contract claim. It's an argument that EPA took action that was inconsistent with the terms of the grant. And after NIH, I don't even think plaintiffs are contesting that that version of their claim is precluded by the Tucker Act. District court also relied on the regulations. The regulations say that EPA can only terminate consistent with the terms and conditions. This court addressed that issue in Ingersoll Rand and said that too is precluded. And at the panel stage, even the dissent agreed that that claim was likely precluded by the Tucker Act. The third claim, or the third variation on the claim, is arbitrary and capricious claim. In other words, whether this was consistent with the grant terms or not, EPA didn't do a good enough job explaining why it had done what it did. That is the claim that was pressed in NIH in California, where the Supreme Court said that it was likely precluded by the Tucker Act, essentially because the APA does not expand the substantive rights or remedies that are available to a contracting party beyond what the terms and conditions of the contract provide. If federal contract law treats a termination as a breach, then the party can sue for that breach in the Court of Federal Claims and recover damages. If not, if the federal contract law does not treat the termination as a breach of the contract, the party cannot use the APA to get broader relief in district court. And this court has said that going back even before Megapulse to cases like Richardson almost 50 years ago, more than 50 years ago. The final claim that the plaintiffs pressed and the district court adopted was the idea that the terminations are inconsistent with the separation of powers or the Inflation Reduction Act because they amounted to a dismantling of the statutory program based on a policy disagreement with Congress.
Mr. Roth, didn't they also raise a claim that EPA violated the Inflation Reduction Act when it terminated the grants?
Yeah, so what they call the separation of powers claim, we think of as a statutory claim that EPA acted contrary to the Inflation Reduction Act. So
Okay,
that's
and-
what
and
I've gotten to.
Bracketing for now, Title VI, Section, whatever it is, 60,002 of the OBBA. I take it you don't dispute that the Inflation Reduction Act made a mandatory appropriation for the greenhouse gas reduction fund.
Well, we haven't really argued that, but I don't think the text of the Inflation Reduction Act did make it mandatory. The text actually just made the money available for grants. There are certain appropriations that say shall, this one does not. Regardless, our point is EPA did make the grants consistent with the statute, and nothing in the statute, let alone the Constitution, prohibits terminating the grants later.
You've never argued that they could have decided not to make the grants.
We
I
haven't
believe you conceded in writing that these are mandatory
I
in
don't,
that sense.
I don't recall conceding it, but we haven't pressed it because, again, EPA did do it. So we think that that ship has sailed. EPA made the grants consistent with the statute. And the question is, can they terminate the grants for the reasons that they did?
Did you have, I don't think you've given authority. I think the default rule is that an appropriation is mandatory. And I don't think you've pointed to anything that would create an exception to that for this appropriation.
Well, again, we haven't really argued the point. So I think that came up in the Global Health Council USAID case where the issue was an alleged impoundment. And so that really got into the question of, all right, what language is mandatory, what language is not? Again, here, EPA made the grants at the time they were supposed to make the grants consistent with the statute. And so the question that was presented here in this case is there a violation of the statute, or as plaintiffs put it, the separation of powers by later terminating those grants? And we have sort of two main responses to that. The first is, even if one thinks that would violate something, the remedy is not reinstating these grants to these plaintiffs on these terms. At most, the remedy for that type of claim, as in Global Health Council, would have been something like, you got to restore the program, consistent with the discretion that you have under the statute. It would not support the injunction the district court entered, which is, again, reinstating the grants as they existed previously.
Mr. Roth, after the Repeal Act, the act that repealed Section 134 and any unobligated funds, could the government issue new grants? Like, does EPA have any statutory authority to reissue the grants? And since the preliminary injunction is forward-looking, I mean, how does the Repeal Act affect this discussion?
Yeah, so I do think it affects it going forward. So the point I was making was, at the time of the injunction, the district court erred by granting relief broader than would have been necessary for the separation of power, so-called separation of powers violation. Which, again, I'll address on the merits as well, but just for that reason alone, it was wrong. I think at this point, EPA could not restore the program because the statute has been repealed. So I think a going forward injunction would be inequitable for that reason. But sort of at the time, that was an option that was on the table. And actually, EPA made clear when it terminated the grants, we intend to reobligate the money. And I know there's a dispute about, under appropriations law, what exactly could they have done with the money? How close would the replacement grants have to have been to the original grants to satisfy appropriations law? But everyone agrees, I think, that there was some way it could be done. Maybe narrow, but there was a way to reobligate the money and restore the program. And that was what EPA said it was going to do. And so to the extent the district court didn't believe that that was what EPA was going to do, the appropriate remedy would have been to order it to do it.
I don't take you to have made a clearly erroneous claim on appeal. You don't mention clearly erroneous except in narrating, I think in quoting something in the panel opinion, and I take that to be a forfeiture of the point. And the district court made a finding that the government had no intention to reobligate the funds.
I think what we said about that was that there was no support in the record for that proposition, which to me is clearly erroneous.
And
There's
did
no
not,
support in the record.
did not develop any argument, because there is support in the record that the district court narrated.
Your Honor, respectfully, I don't think there is. The story is entirely consistent. It started with the gold bars video. It came out in December of 2024. After that, the EPA administrator made clear, even before he was confirmed at his confirmation hearing, that this was a priority for him to figure out what had happened with these so-called gold bars and to address it and to restore accountability to the program. EPA came in January, began to investigate what had happened, discovered the amendments to the contracts and the transactions that had occurred between the time of the election and the inauguration, announced that they were terminating the grants for that reason and that they were intended to reobligate them in a way that was consistent with proper oversight over the money. So I think everything in the record is entirely consistent with the account we have given, which is that these terminations were based on the EPA's very serious concerns with how the grants had been structured. It was not any type of rejection of what Congress had at that point ordered. And EPA was committed to following through on the program consistent with the congressional directive, but not using these instruments. These instruments they viewed as fundamentally flawed because they deprived the EPA of the ability to do proper oversight of the money.
Yet when you go ahead for it.
I'm confused. The repeal of the Inflation Reduction Act provision at issue happened before the panel issued its opinion. And the government filed a 28J letter as that repeal was about to happen. But it did not file any subsequent 28J letter or take position before the panel that the repeal of the Inflation Reduction Act somehow changed the legal posture of this case or prevented the government from reobligating the funds. Am I misstating the record?
Your Honor, I don't remember exactly what we said in the 28J letter. I know we advised the court of the statutory development, and the court didn't ask for supplemental briefing on the impact of the statutory development. The court did address it in the opinion, where it said it was not moot, because if the grants had been improperly terminated, that predated the time of the repeal, and therefore those funds wouldn't be rescinded. That's what the panel said.
And I don't recall you saying in your opening brief that at this point, the funds cannot be reobligated.
We did.
In fact, you said you teed up the issue by saying in your statement of issues, I think it's at page 4, that the issues presented are whether the injunction can be justified on the theory that EPA's decision to terminate the grant agreements and reobligate the funds violates the Constitution or constitutes ultra vires action. And I don't see anywhere in your brief where you say, well, we can no longer reobligate the funds. I didn't see that until your reply brief at page 24. And I've mentioned in passing.
So, Your Honor, we're focused on the injunction at the time it was issued by the district court. And at the time it was issued by the district court, the injunction was flawed because the APA claims, in our view, were precluded, and because the separation of powers, what they call the separation of powers claims, fail on the merits, and we say wouldn't have justified this injunction anyway. Now, the question I got was, okay, well, if this court were to vacate the injunction and send it back, could the plaintiffs, this is how I understood the question, could the plaintiffs ask for a different injunction, one that would say EPA needs to reobligate the money? And I think at that point, they would not be able to do that because of the intervening developments in the statute. But at the time the district court entered the injunction, the error was different.
So is your view then that if we assume the district court got everything exactly right, and we were otherwise going to affirm the district court, then the repeal comes along? And is your view that the repeal just completely changed the universe And therefore, even if we were otherwise inclined to affirm what the district court did, that's no longer tenable in light of the repeal. And the only conceivable result as a consequence of the repeal is there has to be a vacator because there can't be a likelihood of success on the merits in light of the repeal. Is that your view? Or
No, I don't think so.
You don't take that view?
I'm not sure that's what we're saying. I think, and again, it's because there's different claims. So to the extent they're saying, to the extent they were relying on, and the injunction relied on, violation of the terms of the contract or the regs or the APA, right? And the remedy for that, assume the court says, yes, the proper remedy for that was to reinstate the grants as they stood at the time that they were terminated prior to the repeal. Then I guess the court could affirm that. Now, could EPA on remand, terminate them anew based on the statutory developments? Maybe, and that would create a new controversy. But I think the repeal really goes to the separation of powers claim only.
Okay, as to that
Most
claim, then,
directly.
is your view as to that claim that, yeah, put aside the other ones for now, but as to the separation of powers claim, is your view that the repeal changes the universe? So in light of the repeal, there can't be a likelihood of success on the
I
merits.
think it
with respect to
changes
that
it
claim.
in the sense that the only remedy that would be appropriate for a separation of powers violation, again, if that's the claim we're looking at, the proper remedy for that would no longer be equitable in light of the repeal of the statute. Because the proper remedy would be, you got to restore the program. You can't dismantle, this is their argument, you can't dismantle a congressionally created program. All right, so the remedy for that is restore it, but EPA can't restore it because the statute is moved. So I think that part of the case.
But it only goes to the remedy. It doesn't go to whether there's a violation to begin with, the repeal.
I don't think it goes to whether there was a violation at the time, because that
Your perspective.
predates
But
the
Mr.
repeal.
Mr. Roth, doesn't the repeal in part go to the merits? Because the plaintiff's claim, its so-called separation of powers claim, is that claim is not related to the contract terminations. It's contract terminations plus the alleged intention of the government not to keep funding the program. So the separation of powers argument turns very much on what the statute requires. Does it require the government to fund this greenhouse gas program? So the repeal seems to essentially affect that merits part of their argument. I mean, it goes to the remedy, of course,
Right.
but preliminary injunctions are forward-looking. This isn't retroactive relief for a violation in the past. So likelihood of success has to turn in part on what the law requires today.
So Your Honor, look, it's a very peculiar claim to me at the outset, because the claim was EPA says it's committed to the statute. It hasn't said, as in Aiken County, right, where the agency said, we're not doing this. We're not doing what Congress said. Everything EPA said was consistent with the statute. Yet we think that really EPA wasn't committed to the statute. And then on top of that, now Congress has repealed the statute. So it was a very strange claim to begin with. I think it's become an even more sort of twisted claim, because this court would be in the position of, I guess, vindicating Congress's goals and intentions by reinstating a program that Congress has repealed.
Well,
Very peculiar.
their argument turns on the fact that EPA was shutting down the program, and in the interim, Congress has shut down the program. Like definitively, it's repealed Section 134. So
I don't disagree, Your Honor. I just think it was also wrong to begin with, because
But wait, but there's a difference in saying you don't disagree and you actually join issue. I mean, is the government taking the position that in light of the repeal, the merits are done as to the separation of powers claim? Not that it goes to what the relief would be, but is the government taking the position that, because I didn't see that in your
I think
briefing.
we played that into the remedy side of the analysis. I mean, I think they bleed together. So, I think there are different ways of looking at it, but we certainly said that in light of the repeal, this remedy or any remedy would not be, wouldn't really make sense. If the goal of this claim is to vindicate what Congress wanted, Congress has now told us they don't want this program anymore.
Help me understand something. Let's suppose the executive hadn't taken any actions at all, that the money had been obligated, sitting in the Citibank accounts, and then what happens is Congress repeals the Inflation Reduction Act? What would happen to the money in the Citibank accounts at that point?
So I don't think anything would have happened automatically. Like EPA might well at that point have terminated the grants based on the statutory development.
But
And
I
that's in
thought the
fact what
repeal,
happened.
Council, I'm sorry, I thought the repeal was of unobligated funds, but the funds at issue here already were obligated.
Right, so there were two parts. There was a repeal of the statute and there was a rescission of the unobligated funds. And so that's why I was answering Judge Wilkins. The statute would not have automatically done anything to obligated funds. They would have remained obligated absent agency action. But it's possible that under those circumstances, EPA would have said, we're terminating the program, we're terminating the grants because Congress has repealed the statute. And at that point, we would be in a similar position to what we're in now, which is the grants have been terminated, or at least our position is they've been terminated. And to the extent there's any remaining dispute, it goes to what happens to the money post-termination, which is a dispute we're willing to have with the other side as part of the closeout process, and disputes over that can be resolved in the Court of Federal Claims, as they always are in disputes over closeout.
Let me just ask one more question that relates to the point you just made. So the statute does nothing to the obligated funds, the funds at issue in this case. Let's imagine that EPA hadn't taken the action it took in this case, and then it decides, in light of that decision by Congress, only to rescind the unobligated funds. EPA says, well, we're going to leave the obligated funds in place. What would govern those funds? Presumably they would be governed by the terms of the agreements when they were made, right?
The contract would still be there. It would be a little bit strange because the contract talks about how we're going to implement the statutory goals. The statutory goals are no longer there. So it's a bit awkward.
Statutory goals were there. And
yes, that's
the
right.
legislation, as Judge Rao has pointed out, is prospective. So as we typically look at statutes under Landgraf and Varela and other cases, we would assume that that contract that was made would be governed by the statute when it was made, and as expressed and implemented through the terms of the contract. No,
That may be right.
is there anything you can identify that's wrong about that? I assume EPA would have a strong interest in saying exactly, because they wouldn't want orphaned money.
So it's hypothetical, so I can't. It's hard for me to know. There is an analogy.
Answer
though.
hypothetical questions.
No,
all
I'm happy
the
to
time.
answer it as a hypothetical. There was a third part of the Greenhouse Gas Reduction Fund, the solar program. And as we pointed out, at the time of these terminations, EPA did not terminate any of the grants in the solar program, precisely because those grants did not suffer from the defects that led EPA to terminate these other grants.
Let's talk about those defects though, because I'm a little concerned about what you're providing as adequate rationale. First, you start out with no real reason for freezing the funds. For weeks, these parties don't even know what was going on. Then you move on to fraud, waste, and abuse without any true proof of any fraud, waste, or abuse. Then you move on to lack of oversight. So how are we to take that you actually had an adequate reason at the time of you deobligating these funds?
A couple points on that, Your Honor. First of all, the fraud, waste, and abuse language in the termination clause of the contract, whether we can prove that or not is a contract dispute for the Court of Federal Claims. And in contract disputes, it's not governed by the time of the action. We can get discovery and we can resolve it after discovery. It's not an APA posture, and so we're not limited to the administrative record. Putting that aside, the point from the beginning was that the inability to do proper oversight of the funds creates an opportunity for waste and abuse that EPA cannot properly police. For example, several days before the inauguration, one of the grantees transferred close to $3 billion out of the Citibank accounts to a series of private equity funds. We have no idea what that money is doing right now. We have no ability to track it, to monitor it, to oversee it. That is the type of problem that arises from this contractual structure. And that's why EPA was concerned and terminated the grants. Now, whether a particular grantee will ultimately be found liable criminally or civilly for fraud or abuse is we're not there yet.
I thought you had long since withdrawn any assertion. You had any factual basis to believe that a single one of these grantees had engaged in fraud, waste, or abuse. Is that correct?
We have been clear that the terminations.
Is that correct?
not-
Yes?
I'm answering.
correct?
The terminations were not based on
Exactly. So
assertions.
this had nothing to do with why these were terminated.
Well,
Correct.
I'm not sure it has nothing to do with it.
Oh, no, you,
but
I mean, you want
you're not
discovery to go
resting on-
find something wrong after the fact, but it seems,
You're
it seems too late in the day, excuse me, it seems too late in the day after you charged criminality and then dropped that. You couldn't even get anyone to credit that. And then there was charges of fraud, waste, and abuse, and then those have all been dropped. And it
They've
is
not been dropped.
simply, excuse me, that is simply as a basis for termination.
Yes, correct.
Correct.
Yes, I just want to be
Well,
clear.
saying, admitting that something wasn't the basis for termination doesn't mean that if later in the world you discover something, but as of now,
We are not resting on allegations as to particular grantees as a reason for terminating. We're resting on the structural oversight issues. There are investigations ongoing, so I don't want to suggest that there's no evidence of anything. It just wasn't what we relied on for terminating these grants.
I'm puzzled in two ways. One, if the grant structure is the only concern, not the grantees, not, at least not any conduct that has been discovered at the time of the terminations, why terminate? I mean, there's ample authority and opportunity, and I think willingness by these grantees to collaborate with EPA to add safeguards. I mean, there's a real mismatch between the stated ground insofar as it's a concern that there aren't enough guardrails and the action that EPA took here.
Your Honor, I don't think it's a mismatch at all. I think the EPA concluded that the way these were structured was fundamentally inappropriate and unacceptable, and it required doing them over.
And that
And-
the part of it that's, I mean, one thing that I struggle with a little bit is it seems like the aspect that EPA is stating that it is concerned about is the capitalization, that Congress created something that's supposed to create these financial institutions to leverage private investment. And in order to do that, these non-depository financial institutions dedicated to developing energy infrastructure need to be capitalized. That's why, consistent with congressional intent, the money was dispersed early and in a lump sum. And it sounds like what EPA is saying is, no, we think this should be a pay-as-you-go contract because then we have control, we hold the reins. Is that, that's wrong? I can see you shaking your head.
The problem is not capitalization as such. The problem is how it was implemented. So you could have capitalization where the grantee says, we want to do this project. It's going to be this much money. We need it in advance so that we can make it work.
Well,
We
what
give it
about
to
you're
them in
creating
advance.
a nonprofit finance institution to do that, consistent with the
and-
notion that private actors
And
can
that can be
sometimes
done-
do things better. So are you saying the problem is that the financial institution is not within the government?
No, the problem is that once that gets off the ground, so EPA deposited the money in this account, and its ability after that point to exercise any kind of oversight or control of the funds is extremely limited, which is not necessarily true for any capitalization. You could have a capitalization where EPA needs to sign off on particular projects. You could have a capitalization where EPA needs to have a contractual relationship with subgrantees so that it has an ability to audit and monitor the subgrantees. There are many things that can be done consistent with capitalization that would allow EPA to see where the money is going, make sure it's being spent appropriately.
And those things cannot be done with these current grantees as EPA.
Oh,
thought about that?
maybe it could, but not under these instruments. And so the point was, these instruments don't work. We need to start over.
About these
There was-
instruments precludes that? I didn't see anything about that in your report, let alone in the account termination, in the,
Yeah,
in the
it's-
notices of termination.
It's all about the rights that are given, or in this case, not given, under the agreements that were created and implemented. So, for example, EPA has the power under the grant agreements to, or it has the obligation under the grant agreements to sign off if a grantee seeks to withdraw more than 10% of the budget amount in a particular transaction. Okay? That is a huge amount. Why couldn't it be 1%? Or for any transaction, right? You could have terms that better preserve EPA's ability to say, well, I need more information about that project before I'm signing off on that one. Under this arrangement, EPA cannot do that. And that is what EPA determined is a problem, because it meant the money was in Citibank accounts, and there's very, very limited ability to ensure that it gets used for its proper purposes.
And it's your position that those assurances could not be provided with the ongoing contracts.
Well, I suppose we could have gone to them and said, we have no leverage, but would you like to agree to additional constraints? And maybe they would have said yes, and maybe they would have said no. But I don't think it was unreasonable under those circumstances to say, we're cutting this off right now, and then we can start over on fixing it. I mean, think of any business owner. New business owner comes into a business, CEO starts, looks through the contracts and finds a vendor agreement that he says, wow, this vendor agreement is completely one-sided. It gives us no rights to ensure that this relationship is appropriate. We're canceling it. And I think I can cancel it, but if it turns out to be a breach, I'll pay damages, but I can't live under this agreement. We'll figure out a new vendor agreement. It's not an unreasonable way to approach
I
a
think
situation
most
like
businesses
this.
would go to the person and ask to renegotiate. I assume these contracts, they all look identical. I assume they were drafted by the government.
I don't know, Your Honor, it predates the administration.
They're all identical
They're
for all
yes,
our
they're-
grantees. Are you aware, you've been in the administration now for a while, that the administration allows grantees to write their own contracts?
Your Honor, I think there are a lot of questions about how these contracts were put together.
I'm asking about the practice in the
I
government.
don't know who
I think we
wrote
can
them.
probably take judicial notice. The government wrote these contracts. And the
Fine.
business owner that writes a contract and executes the contract, and the other person is performing under it, is performing fully satisfactorily, no basis to believe that there's been any non-compliance, any questions about performance. Comes in and goes, oops, wish I hadn't written the contract that way. I'm freezing up the money I already gave you in your bank account. You think that's a rational way for a business to proceed?
I think it's absolutely was a rational way to proceed here, because there was a change in leadership between those times.
I'm
And
asking if a business, I don't care who the leader, yeah, I'll give you a change in leadership in the business.
And the new leadership said, this
What's your
contract,
best case authority? Or statute, regulation? That is the proper way of proceeding when, assume for answering this question, the government drafted the contract.
Your Honor, the general EPA terms and conditions that were in effect at the time of this contract gave EPA the right to terminate the contract based on
There's
its
much debate
policies.
about that, and whether that
Not.
carried it, right?
They did
that's-
not.
We read it differently, Your Honor.
They did not. The EPA had accepted the invitation to have the incoming standard terms, which said the only way you can terminate based on policy priorities is if that is included in the text of the contract itself. And everyone knows that that was not included. So there was an opt-in rather than an opt-out. And I just don't see how you can continue to so assert, given that you're aware that EPA as a general matter had opted to take the new regulations as of July.
Can I make 2 points in response, Your Honor? Number one, JA 518 is the provision of the contract that says the general terms and conditions are incorporated. Later in the contract, they say for termination, we're limiting ourselves to this, but it does not restrict that initial provision that says it's the general terms and conditions are incorporated and nothing herein is intended to change or modify
And at
those.
the time the contract was entered, the general terms and conditions did not allow that
That respectfully, that's-
termination for policy priorities.
I don't think that's correct. Your
As
Honor.
of July, I think it was July 3rd.
It didn't take effect till October.
No, it took effect generally throughout the government in October. But OMB said, anybody who wants to take this on earlier, have at it. And there's a publication in the Federal Register saying EPA raised its hand and said, we want to sign on to that as of July. And you just haven't grappled with that in any way.
My understanding is that the signing on was generally going to take effect in October.
Generally
that
for other
this-
agencies, but EPA said,
Okay.
we're doing it at July 3rd.
So let me make my second point, Your Honor, which is to the extent the court disagrees with our reading of the termination clause, the consequence is it's a breach of contract. And you can breach a contract and pay damages. And we're prepared to litigate that issue in the Court of Federal Claims. We'll explain why we think the termination is appropriate. If we lose, we will pay damages.
You were saying you didn't have any leverage, and then you had an exchange with Judge Millett, and where she was questioning the basis for the freeze, but it just underscored for me why terminate, where you could have frozen the funds and then turned to the grantees and said, look, we don't feel comfortable with this rolling out. Let's work out something different. Tried, not tried, considered?
Your Honor, I don't know why that would be functionally any different.
Okay,
So
it wasn't
the
considered.
termination is,
I have some questions about sort of the scope of relief. What effect do these notices of termination have? For example, if the court were to order that the funds in plaintiff's account at Citibank be unfrozen, but it didn't enjoin the notice of contract termination, what would happen next?
so just make sure I understand the question, Your Honor. This court vacates the injunction that enjoins the terminations. Then the question becomes, what happens to the money, right? That is, I think, governed by the closeout procedures under the grant agreements. And as part of those closeout procedures, maybe plaintiffs will assert, we get to keep all of it. I mean, I think that, I'm not sure how they will be able to make that assertion after challenging the terminations, because the whole premise of challenging the terminations was, if you terminate, we're not going to get the money anymore. And of course, now they've changed their tune because they recognize the difficulties.
Also in the plain text of the closeout agreement.
So
Plain
then they
text
can-
of the closeout agreement, that if they check the required boxes, they retain the funds for continued use consistent with the program.
So they can make that argument?
But that's the plain text of, I mean, it says it
And the
there
plain-
in terms, and so.
And the plain text of the termination clause is that we have to reobligate the money if we terminate. So they can try to reconcile those two things and as part of the closeout, and we can litigate it. But
Well,
that's,
you reobligate any money that's left, but if the contract says they end up keeping it, then there won't be anything left for you to reobligate. It's a perfectly reconcilable reading of it.
okay, so we can have that dispute as part of the closeout
Okay,
process.
but I mean, you were sort of dismissing how crazy it would be to think they get the money. I'm just pointing out that it's right there in the closeout. Again, you all
I think
wrote
if-
the
if they-
contract.
I think if they really thought that was correct, they would have been thrilled when we terminated the contract, because they would have keep $20 billion with no strings attached to it. Instead, they sued
Well,
over
no, there are
termination
still
of the
strings
contract.
under the closeout agreement. It has to be used for the statutory purposes. And I think they've explained themselves before that this was a program. They wanted to go forward, working with it in the program and working with EPA to the extent EPA wanted to work with them.
Right, so EPA doesn't want to work with them anymore. That's why I terminated the grants. And again, if there's a dispute over closeout, we can have that dispute after the grants are after the terminations are effectuated, but it's not the question that
Then
we're here on.
then we get to, at least for me, I guess. I take, they assert title to these funds in their accounts, and the government disputes that status. But I haven't, I'm very confused on this record as to what the status of the money in their accounts is. Is it still, until it's, so it's put in their accounts, and then the idea under the statute is they then put it out for other investments. So is the government's position that it remains the government's money until it's put out, joint money?
Yeah, the best I can do, Your Honor, is I think the money is held by Citibank in the names of the grantees, and it is subject to being used by the grantees consistent with the terms of the contract. And it is also subject to being the notice of exclusive control and other rights that EPA has to block or take back the money. So it's a pile of money that is in the bank account that is
Whose money
governed.
is it when it's in the bank account?
It's
surely not Citibank's.
Both parties have certain rights under the contract in the funds. So I don't know how to answer.
Right, they
If you
have
say
legal
it's
rights.
held in the name of someone, doesn't that mean that it belongs to that someone?
Well, I don't think it's quite that simple because there are restrictions on it. And so there are, they can't just withdraw it and spend it on anything they want. And we are entitled, EPA is entitled to assert control of the funds under certain circumstances. So again, I think it's, the contracts spell out the competing rights and obligations of the parties with respect to the money.
So is it fair to say, I mean, you can have a thing that's sort of clear and unencumbered title, and then you can have encumbered title. I mean, it sounds to me like what you're saying is they may have title, but it's not clear and unencumbered title because there's certain entitlements that the EPA has with respect to the same race. So it's,
I think it's certainly true that they don't have clear and unencumbered title. I don't really know exactly how to answer the title question or why it matters. I think the key question or the key threshold question is, do we have a live contract? In which case the money is in that account and everyone agrees it's subject to these rights and obligations, or do we have a terminated contract? In which case we have to go through closeout and figure out what happens next. And our position here is we're in the second bucket.
Mr.
But you'd
Roth,
have to, oh, go ahead.
sorry, but I mean, the government cites Judge Posner's opinion in Joliet will, which suggests that in this sort of circumstance where money is held either by a grantee or a third party, it remains the property of the United States until it is spent for the grant purposes. And the same reasoning is true under cases under 18 USC 641, which involves conversion of government money. You can be criminally liable for converting money that is held by a third party. So why do those, I mean, the government has cited those cases. So, and this circuit has favorably cited in Joliet will in other contexts.
I think what I'm trying to say is the question of exactly how to characterize the status of the money while the grant is operative is tricky in certain ways, but it also doesn't matter for what we're doing now. Because what we're doing now is terminating the
Well,
grant.
it's, for some of us, it might matter, or at least potentially be relevant. And we said, as Judge Wilkins pointed out, this is money in their accounts. They are called the pledger under the agreement, and they grant the government a security interest. The government doesn't come in with it. They agree to grant the government a security interest, which the government would need if it was already had a possessory interest. So what the government has been granted by these grantees, forgive me using the word twice, is a security interest, which suggests they have enough legal interest to be able to do that. They pay taxes on the earnings on this account, which would be odd if it wasn't their income. The closeout agreement allows them, if they go through the process and comply with all of its terms, to keep these funds, which would be extraordinary if it wasn't theirs on a couple of reasons. One, it would just plain be extraordinary, but two, the executive branch has no legal authority by regulation or contract to give federal funds to private parties. Only Congress can authorize that. So Congress, on the assumption the government was acting appropriately, only Congress could have authorized allowing them to keep it. And that's certainly consistent with the vision under the IRA of how these things are to proceed. And so the reason, I'm sorry, the reason I'm putting all this in there, you seem not so interested, but is if they've got some sort of substantial legal interest, probably a property interest in these funds, this starts to look exactly like Crowley, which involved this exact type of bank account in a third party in the name of the contractor, and then government agents coming in. There, they didn't freeze the whole thing, they just pulled out chunks of money. But you had this exact same financial setup involving bank accounts in a third party in Crowley. And we treated the request for declaratory and injunctive relief prospectively against, there it wasn't a freezing, it was scooping out $37 million as something that could go forward, did not need to go through, to the Court of Federal Claims. Didn't we? In Crowley?
Crowley held that it was not a contraction. Yeah. the
It was
claim
this
in Crowley
exact
was
same
not-
setup, a bank account just like this.
Your Honor, my recollection of Crowley was that the court said it was really a tort claim and it was
Yes, they're right.
being
They're-
exercised by
yes.
by a non-party to the contract.
It's still the
Here-
executive branch. It's one big executive
but-
branch, right?
Well, for certain purposes. Your Honor,
I'm sorry,
the difference
for not
is-
for present purposes? For present, I just didn't hear what you said, I'm sorry.
no, I said yes, for certain purposes, that's true.
But not for this purpose.
The EPA is the party to one of these contracts. Treasury is the party to others. I don't think if they sued, the Department of
You think
Interior,
Crowley would have come
it
out?
would be the same fact. It would be the same scenario. The scenario here is EPA is
So if in
part.
Crowley, the Defense Department had said, hey, GSA, I don't like these contracts that we wrote. Can you like audit them? They actually were doing audits.
Yes,
And start scooping some of this money out for us. That would have been a different answer.
So, Your Honor, I think the key point and the key difference is that was not a termination of the contract in Crowley, and it wasn't challenged to termination of the contract in Crowley.
No
was something
violation, but it
collateral to
was
the
definitely
contract.
argued by the government that it was arguments about violating the contract. And contract, claim. The government's position was as it was here, that there should be a contract claim in the Court of Federal Claims, Correct?
And here,
correct?
I don't remember, Your Honor.
Of
exactly
course you
what we
do. That's why
argued.
the case was
in-
decided the way it was.
Um,
You've read it, come on.
I have read it. My recollection is that what the court said is that. it
Yes,
was a
I just
tort
asked you what the
claim.
government said in that position was in
Okay,
that
well,
case.
government lost that case. Here, there's a termination of a contract, which this court has said since Ingersoll Rand, you're trying to undo the termination of a contract, that's a contract issue.
Just asking in Crowley, you had the same exact same, which you did not have on Ingersoll. Exact same scenario, funds already deposited in an account in the name of their contractor rather than a grantee. And the government is then taking money out, say freezing small portions of it would be the equivalent of what's going on here. And we set a request for prospective injunctive relief against that. Can go forward.
And Your Honor, that's not what this injunction is. This injunction doesn't do that. It says you cannot terminate the contract.
It also says, it also required you to, undo the freeze on the funds.
The
So I mean, there's two
freeze-
things
yes.
happening here.
The freeze, the suspension, which was Treasury telling Citibank not to disperse the funds, lasted for a week and it's been done for a year. The termination that came in and
I'm sorry, what's done for a year? Are they, they're still frozen at,
no,
the government-
no, Your Honor, they're frozen because of this court's injunction.
right, to be clear, I'm sorry, yes, to be clear, but from sorry, I wasn't clear at all. Had the district court's injunction not come in place, the government had gone beyond freeze them for a week and said, keep them frozen until
No.
we tell otherwise.
No, the termination, the freeze, the request that. Citibank-
Suspension, whatever you want to call it.
Yeah, the request that Citibank not disperse was while EPA was figuring out what to do. EPA then determined to terminate the contract. That replaced any prior directive or action.
So you no longer believe you have a legal right to have a suspension or freezing of these funds?
So I think it's moot. I think that part is moot. To the extent there was a pre-termination directive, like that's not what this case is about anymore because that has not been in place for a year. And that's not what we're relying on. And that's not what we're objecting to. We're objecting to the injunction against the termination. The termination didn't freeze anything. The termination said the contract is over. Let's proceed with closeout. Please give us your report.
Okay, so, and then what happens during closeout? They can go ahead and
Yeah.
going forward and spend this money now under your view.
That they can try that if that's what they want to do. And maybe we'll have to sue them. Maybe they'll have to sue us again. There's lots of different ways this could play out after the termination takes effect, but we're not there yet. And I do think it's really important that we take this one step at a time.
I have just a small question going back to the exchange you had with Chief Judge Srinivasan and Judge Millett about the Joliet Posner decision and whether Citibank is sort of in the position of a dispersing officer. And as I read those cases, that Citibank is not a dispersing officer because the dispersing officer is a government officer, and this has already been sent out to a private party. And I understand that the agency agreement you characterize and Citibank is for certain purposes an agent of the government, but you don't have any authority for treating a private party as a dispersing officer for purposes just of that point.
Your Honor, this is a very unusual structure, and so I don't
No,
have something to
and
point
my
to.
other question is, for your Tucker Act argument, does the government need to have a contractually non-frivolous ground for terminating the contract to make the plaintiff's relief sounding contract?
No,
Doesn't need to
No,
have a non-frivolous
because if
ground. It can have a
if we
completely frivolous ground.
because we can breach, we can terminate for no reason, and it would be a breach. If
So
it's,
you do take the position, I saw you adopted that from the panel opinion, that the government may, at its option, engage in what I think you referred to as efficient breach.
government,
So-
like any other party, can breach a contract and pay damages. Now, there are some doctrines that the Court of Federal Claims and the Federal Circuit has adopted that limit that by essentially saying it's sort of akin to, good faith and fair dealing type arguments. The panel opinion cited you can't breach with impunity doctrine, but those are doctrines that treat certain terminations as breaches, even though they may be consistent with the literal terms.
So let me ask you, if putting aside the facts of this case, if there is a mandatory appropriation that says this money shall be spent, during the coming year by X date for such and such a purpose, and the government spends it for that purpose and gives it to, whatever functioning entity is doing the actual work. And then there's a change in administration and the new government says, we have different policies. We're just gonna engage in efficient breach of that contract. And we're gonna have to pay some damages on that and it'll just be done. Lawful?
I think from a contract and APA standpoint.
From
they
a
can do that.
statutory, I'm
From a
talking about
stat-
from a
so
statutory.
Statutory, somebody could sue and say, you're not complying with the statute.
Contrary to
you-
law,
Like an impound, it would be essentially an
It would be an
impoundment
impoundment
type claim.
and would that claim, that's the whole thing. Would that claim have to go to the Court of Claims under the Tucker
I
Act?
don't think so. I think that claim would go to district court, but the remedy for that claim would not be reinstate the contracts you terminated to those particular grantees. They would have to go to the Court of Claims if they want relief
What would
for
the relief
themselves.
be?
It would be, you have to spend the money.
Why wouldn't the remedy be you can't effectuate this termination notice because this termination notice was contrary to the statute?
Because it's not the specific termination that is allegedly violating the statute, it's the not spending the money. The agency does have
But
some
it is, isn't
discretion.
it? You could think of these, each termination is final agency action. If it violates the statute, the ordinary remedy is to set it aside. Maybe the next day, the government could do a termination that doesn't violate the statute, or
Right,
isn't.
So, and I don't want to lose sight of the fact that we don't think that the terminations here were contrary to the statute, because we.
Totally
By
understand.
putting that aside, it's not a one particular termination that is a violation of the statute. It would, on the hypothetical, it would be the decision to terminate and not to use the money for the statutory purpose.
Right,
And the
and
remedy-
that's where it seems like your argument that the OBBA would not allow you to spend the money actually strengthens the plaintiff's position in this case, that there is a violation of the appropriation because this is a 2022 appropriation. The Congress wants this program. The money is dispersed. The act reflecting the view of Congress, we're not going to take back money that's already been obligated, but we're going to, take whatever hasn't. And you're saying we persist in wanting to take this money back, but we won't have any way then to spend it.
Your Honor,
Why is that not?
I don't see how a subsequent legislative action could render what we did unconstitutional.
I'm
back
not
in
saying
time.
unconstitutional, I'm saying contrary to the act. And I
Well,
think it's very closely parallel to the constitutional argument, but just to simplify, let's say contrary to the act. And it isn't rendered unconstitutional, but I don't think it's rescued either by the OBBA, which doesn't address these funds. So put that aside and say, you do intend to re-obligate. If the district court is right, and you haven't challenge as arbitrary and as clearly erroneous, it's finding that you didn't intend to. Plus, if it turns out that you have no legal authority under the replacement grant to give to anybody else, statutory violation, it seems to me you'd have to concede in that situation.
No,
Of course,
I
there's a
don't, Your Honor.
statutory violation.
No, I don't, Your Honor, because there's two relevant time periods. There's time period A, when the contracts are terminated and the intent is to reobligate. That's perfectly
The
consistent with the
district court
statute.
found no intent to reobligate.
And we 100% have argued very forcefully in our brief that there was no basis in the record for that finding. We use the term no basis because it is that clear in the record that nothing EPA ever said suggested that they were not intending to comply with the statute and reobligate.
Counsel, if I could then
At
point
time
you
two-
to a few parts of this record. The president issued an executive order purporting to terminate the Green New Deal, okay, by directing all agencies to immediately pause the disbursement of funds appropriated through the Inflation Reduction Act. Then on February 12th, the EPA Administrator Zeldin publicly announced that, quote, the financial agent agreement with the bank needs to be instantly terminated, and that Citibank must immediately return the funding, and that EPA is not going to rest until it recovered the grant funds. Then on February 23rd, when describing the grant program, Zeldin stated that the entire scheme, in my opinion, is criminal. And then on March 4th, Zeldin announced the money is now frozen. Clearly erroneous is a very high standard. The district court found that the EPA seeks to dismantle these grant programs in their entirety as a policy matter. This evidence supports that. And even if you think it could be read differently or you would credit different evidence other than this, it doesn't meet the clearly erroneous standard.
Your Honor, it's clearly erroneous because everything that Zeldin and the EPA said was entirely consistent with the narrative that I've given here, which is that the concern was with the way these grants were structured and implemented, not with the congressional program.
But there's a problem with the whole program. It's criminal.
There's not a problem with the whole program. There's a problem with how
Well,
it was
regardless of
implemented.
whether it was or not, the district court could reasonably not credit the government's allegation or statement that it was going to reobligate the funds and instead credit the evidence in the record that they sought to terminate and dismantle the programs. And it's not clearly erroneous, even if you disagree with it.
I think it's absolutely clearly erroneous. It is all of the evidence in the record.
I know
is-
you think that, but I'm saying that there's evidence here.
There isn't
And
evidence that.
for you to prove that it was clearly erroneous, you would have to show that there was no evidence to support it. And I've just read to you evidence that does.
None of that evidence suggests that EPA wasn't going to re-obligate the money consistent
Why
with the
doesn't it?
statute.
If he's going to terminate the program,
He said
you're
he's
not
gonna
going to
terminate
reobligate the money.
grants. He was going to terminate the grants and terminate the financial agency agreement because the
He was
problem
terminating the Green
grant.
New Deal. That's the entire program. It's not just these specific grants.
Your Honor, that's the
We don't
EO.
have to quibble about whether it's true or not. I'm just saying that there's enough evidence here
Okay.
for the district court to discredit the government's statements that it was going to reobligate and instead credit the statements it was going to terminate the whole program.
I respectfully disagree with that interpretation of the record.
And
And I would just note that the EO that Your Honor is mentioning postdates the statements from the EPA, then the nominated administrator, he hadn't yet been confirmed, but he had said long before that, that because of the gold bar video, his top priority was finding out what had happened and restoring that money to government control.
Counsel, you can point to evidence that you think favors your position. All I'm saying is that the standard of review is clearly erroneous and there's evidence here to support what the district court found.
So then let me say that if that is correct, the remedy for that would have been, I don't believe you have 60 days to reobligate the money. That's not what the district court did. The
All
district
right,
court-
Mr. Roth?
But if I can just, I'm sorry, Judge Roth, if I can just finish then. It seems to me then you have conceded that if in fact the EPA intended to dismantle these programs, that would be at least a statutory violation, if not a separation of powers one. You agree with that, right? They can't just dismantle these programs that Congress has.
We've certainly not
enacted.
challenging the point that the agency has to follow what Congress says.
Okay, so you agree with that?
Congress, EPA
So-
did follow what Congress
Okay,
said.
I understand. So I guess I just want to underscore that this is a factual dispute because the district court found that EPA sought to dismantle that, which you agree would have been erroneous. And so that part of this case, the statutory separation of powers thing, boils down to this factual question.
I think I'm not sure it's really a factual question. I mean, it's a question about.
Well, it's a factual
intent.
question whether or not you intended to reobligate and therefore didn't violate the statute according to you.
If you want to call that a factual issue, then that's the.
How is that
finding.
not a factual issue?
Well, I mean, I think we're looking at what is the presumption that the government gets?
Which
on
is
these
still a
points?
factual issue. It's a factual issue, whether or not you intended to reobligate or whether or not you intended to dismantle the whole program. That's
Maybe
factual.
ultimately it is. There's a presumption of regularity that attaches.
That's fine,
so-
but there, in no world is that not a factual question, is it?
If it is a highly factual issue, unique to this case, why are we on bunk?
Good question, Your Honor.
I also have a question about the factual. I mean, if we do credit the district court's findings of dismantling, that only goes to the so-called separation of powers statutory argument, because plaintiffs have made no argument that the so-called dismantling fits under the APA. They never made such a claim in district court. They never made such a claim before the panel. Is that correct?
That's correct.
That is so not correct.
So,
I mean,
so
Isn't that arbitrary and capricious?
can I finish? Right, say they argue that it was arbitrary and capricious to terminate the contracts. They only argued, they did not argue the dismantling claim under the APA. The district court did not address the dismantling claim under the APA. So, so even if that dismantling finding is credited, it only goes to the so-called separation of powers statutory argument. And then that argument has now changed because Congress has in fact dismantled this program. Am I matching up the claims correctly with the facts? I mean, the facts, they're different claims that were brought by plaintiffs under the APA and under the so-called separation of powers statutory claim.
Yes, Your Honor, I think you are correctly aligning them. The claims that the district court ruled on were three. One, the terminations violated the terms of the grants, it's a contract claim. Two, the terminations violated the regulations because it was inconsistent with the terms, contract claim under Ingersoll Rand. And third, EPA intended to dismantle the program, and you can't do that, whether that's statutory or constitutional.
But that's the
That's the
equitable claim.
claim on which our point is, okay, well then the remedy would be
Can I
restore the
just-
program.
So
which
the
they can't
fact
do.
finding doesn't actually matter
Court doesn't need to
for,
reach
for the
that, right.
APA claim because they never brought a dismantling as contrary to law under the APA claim, either in the district court or before the panel. They are now trying to recharacterize it in their briefs here, argument.
I think that's correct, Your Honor.
Can I just ask you on that score? So on page 20 of your reply brief, there's a paragraph bringing us to start. The remedy for a constitutional claim, parentheses, or an APA claim, parentheses, the challenges of an alleged dismantling of a statutory program. So that at least hypothesizes there's an APA claim that deals with dismantling.
They've started to raise it in their briefs. I think at least one of the briefs in this court and on bank proceedings has made the argument, but it wasn't the argument below. It was during at the panel stage, which I understood Judge Router, yes.
I see. So when you hypothesize or an APA claim, you're not, what you say, you
Responding
meant
to
to
their brief, yeah, responding to the point in their brief.
Hmm.
I mean, ordinarily, the remedy for an APA claim for failure to explain would be, give a better explanation. It also wouldn't be reinstate the grant. I mean, this is a fundamental mismatch here is the order that the district court entered, which is reinstate the grants. That is the classic contractual remedy of specific performance, which is what this court said 40 years ago in Ingersoll Rand. It's what the Fourth Circuit said last month in Sustainability Institute. If you're trying to reinstate a contractual relationship, you're in the wrong place.
Can I ask you just on just to flesh out one thought on the effect of the repeal? So you started to get into the solar funds because those hadn't been terminated, at least as of the time of the repeal.
Right.
I mean, another way to ask this is the same question, I think, is where you're going is you've made a lot of statements today about the ability of the agency to oversee the administration of the program and that there were some deficiencies in that regard. So after the repeal and the rescission of the unobligated balances, what happens? Is there still the ability on the part of the agency and the government's perspective to engage in those kinds of activities vis-a-vis, for example, the solar funds or vis-a-vis a situation in which there wasn't a termination? Because I didn't understand you to be arguing that the government lacks that ability in the aftermath of the repeal/rescission. And it didn't sound to me like your argument today takes that position.
So what I can tell you is that on the solar funds, they were not terminated at the time of these terminations precisely because the problem was not with the statute, it was with the implementation of the NCIF and CCIA sub-programs. After the repeal, the EPA did terminate the solar program, the solar grants, and said that's because of the statutory development and because our money to administer and oversee the program was rescinded. And so, we're going to terminate it as a matter, not necessarily that the statute requires us to terminate, but we are going to terminate in light of the statutory development. But that's how they handled the solar program.
So would the same thing have happened if there hadn't been a termination already with the non-solar part of the case, i.e. the non-solar part of the statute, i.e. we have before us today?
Right.
What is that?
I mean, it's counterfactual. I don't know. It's possible. It's possible that they would have terminated for that alternative ground after the repeal, but we never got there because they repealed for a different reason. They terminated for a different reason 6 months before. And at that point, the anticipation wasn't that it was going to be repealed. The anticipation was we're going to have to reobligate this money in short order, and EPA was preparing to do that when the district court cut that process off.
Council. I just have two legal questions, which I hope will remain legal questions. So the first is, we've had a lot of discussion of the statutory claim. Obviously, there's one question about intent to reobligate. Do you agree that you also need to show at least some possibility that you could have reobligated? So if, for instance, I know you would dispute this, if there was a categorical prohibition on a replacement grant in this situation, would you agree that the statute's been violated because, sort of intent aside, objectively, there's been an impoundment? I'm just trying to figure out if you think we need to answer that question of the availability of a replacement grant.
Yeah, so the hypothetical is, let's say there was no way to reobligate. It was impossible. I still don't think that would be a statutory violation because the purpose of the termination wouldn't be to thwart what Congress wanted. It would be because these instruments were unacceptable. So I still think they wouldn't be able to get to the point of saying it's a conflict with the statute.
Even if the result is, say, $10 billion of the appropriated money is
And
not
the best
spent.
the best way to think of that is imagine that one of these programs only had 3 grantees. Okay, let's assume that the 3 grantees were all convicted of wire fraud and we terminated them. Would that violate the statute? I don't think so, because the purpose of the termination was, well, these grantees are criminals. And so for the same, in sort of parallel fashion, if the grant termination had not been based on, we don't care what Congress wanted, we're not interested in doing this anymore, then it's not a violation of the statute or the separation.
Okay, and thank you. The second is different. It's about Tucker Act. So it's certainly true that most things we think of that are claims that a termination of a contract is arbitrary and capricious should go to the claims court. But that's because if you have a situation like in Richardson, where that really does turn on debating the terms of the contract. What if you have a claim that is just the government has stated some reasons for terminating my contract, but they're entirely pretextual? Resolving that claim, it seems, wouldn't require looking at the contract at all. And we're supposed to be asking whether the claim is founded on contract. Why wouldn't a claim that a termination is pretextual be proper in district court?
Because, Your Honor, if the termination was pretextual, and if the pretextual reason meant that the termination was inconsistent with the contract, you'd have a breach claim. So your breach claim would be, you've terminated in violation of the contract. Government says, oh no, what are you talking about? We have a great reason in the contract, misconduct. And you say, well, that's pretext. There's no misconduct. That's the debate we would have in the claims court over whether it was a breach or not.
But isn't there sort of a value recognized by the fact that we have the APA in having the government state its true reason? So you would set aside this termination, require it to, it's not a very good remedy because all it gets you is the government has to issue a better termination. But why shouldn't that be allowed to play out?
Here's a hypothetical that I think of that helps me understand this. Imagine you had a contract that said, either party can terminate this contract by sending an email to the other side that says, contract is hereby terminated, okay? Government sends the email, contract is hereby terminated. Party goes to district court and says, this is boilerplate. You know, nothing about reliance interests, nothing about the reasoning, APA violation. Nobody would think that's a proper APA claim. If it's permitted by the terms of the contract, it's not going to be an APA violation. The world of federal contract law existed before the APA, and it determines what the government can or cannot do with respect to breaching or terminating a contract. And the APA does not speak to that. That's what I understand the point of the preclusion.
Could I,
Oh, no, you go ahead.
could I just take you back to the Inflation Reduction Act dismantling claim? Following up on Judge Rao's questions, let's assume that all relevant claims and theories of review are preserved. I still wonder whether the IRA dismantling claim is judicially reviewable. And I'm thinking about some things we said in the CFPB case from this afternoon. You have a bunch of individual termination decisions, which by themselves are wholly lawful. And you put all of them together and consider some of the pungent statements from the president and the administrator, and you infer from that a district court here said dismantling decision, one could say the decision to shut down this program. That seems to me not final agency action reviewable under the APA for reasons explained in the NTEU panel decision, and then not judicially reviewable through ultra-virus review because any one of these plaintiffs has an adequate remedy in the Court of Federal Claims. So you don't have the APA as a mechanism for review, and you don't have the Hail Mary of ultra-virus as a mechanism for review. So end of claim.
I'm not going to disagree with you on any of that. I would like to win this case regardless of what happens this afternoon. And I think the point that I was hoping to make was, to the extent that that was a reviewable
I mean,
claim.
you either go that route or you're fighting the dismantlement finding as clearly erroneous on the facts.
Or we're saying it doesn't matter because it doesn't justify this injunction. If the problem with it, because you got to match up the agency action with the remedy. So if the final agency action is termination of Climate United's grant, then the remedy would be reinstating Climate United's grant. And that runs into the Tucker Act problem. If the supposed agency action is shutting down the program.
Yes, you have that remedial argument on mismatch, and you have this whole question about what's the impact of the repealer. But before you get to those remedy questions on the back end, it seems to me you either have this no judicial review theory, or you're fighting the dismantlement finding as clear error. And I would think you'd rather have the former, or at least you'd rather have both.
They're both available. Again, recognizing the different views on what the evidence shows, I looked at this record and I watched the video of the administrator, and I said, there's absolutely nothing here. I mean, everything he is saying is consistent with what we've said from the beginning, which is that the problem was the money was put into this account with no oversight ability so that it can be moved around and used, and nobody will have any idea what's going on with it. And that is unacceptable to the EPA. And so EPA is going to do something about it. There was not a word about how the Congress was off base, or this is a bad policy, or green banks are a waste of time. Nobody said anything like that because that was not the problem.
Except the President of the United States.
And that was
and
after.
Administrator Zeldin.
The administrator did not say that. The president issued an executive order that was after the administrator had already committed to this at his confirmation hearings that predated the executive order. This had nothing to do with that executive order. It was completely independent of the executive order. And it all goes back to the Gold Bars video from 2 months beforehand.
Zeldin described the program as a clear-cut case of waste and abuse and a criminal scheme. That is not saying these contracts were not done correctly, we're going to redo them.
It is. That's exactly what it was saying, that the way it was structured was, in his view, criminal and it was wasteful because it means that the money cannot be tracked, cannot be monitored, and we cannot ensure that it's being spent properly.
Regardless, you just have not in this case made the argument that there's an absence of APA final action. For the reasons you made strategic
Right,
judgment.
the way we've been thinking
You
about
haven't
it,
argued it in your brief at all, so it's forfeited.
the briefs say what they say. The way we've
That
been
you
thinking
have
about
you,
it.
I just want to make sure, because we've read a lot of briefs. So if I missed it, please tell me. Did you make the lack of a final, however you want to call it, lack of final agency action, discreteness requirement for AP claims? Have you made that in your opening brief in this case to this court, on bank court?
I don't think so, Your Honor.
Okay.
I
And if
think
you
what we
haven't-
said was,
If you haven't, it would be, that argument would be forfeited.
I think what we said was.
That argument would be forfeited if you had not made it in your
That's a
opening brief.
legal question for the court to decide. We are, what we
Under our
argued
precedent,
was,
your argument would be forfeited and have not made it.
maybe that's right. What we said was the agency action that they sued over in the district court was the termination of their individual grants, and that there is no way to
I'm not,
justify that.
I'm
injunction.
not critiquing at all the judgments that were made here about which claims to press and understand why you've done and it worked for the panel. So, and it may well work here, but I'm just trying to clarify and make sure I didn't misunderstand your brief. And
I don't think you
I take
misunderstood.
it from you that you have not pressed that argument. Can I ask just one more procedural question that this does relate to the repeal issue, and you may have already said this and it just hasn't registered with me. So if the injunction is lifted, as in your view it should be, to me again, what happens in your view to the funds in the Citibank account?
Well, they can't spend them right now because with the grant being terminated, they can't certify that a disbursement would be necessary to, to comply with their work plan because there's no more grant. So I don't think they can spend the money on projects if there's no live grant.
Mhm.
I think they are supposed to provide EPA with a closeout report,
Mhm.
and then there will be some back and forth over who owes what to whom. And then that's how that will.
Would
get
the
worked out.
government have the authority in its view, when the injunction lifts, to direct Citibank to return the money to the Treasury?
I don't know that we can direct Citibank to do that. I think we could terminate the financial agency agreement.
Mhm.
Treasury could terminate the financial agency agreement.
Mhm.
And then Citibank would have to figure out what to do. with
What
the
happens?
termination.
I'm really just
I don't
trying to
know.
understand.
I mean, I honestly, I don't know what is going to happen because we never got there. And this could go, I think, in 10 or 20 different directions, depending on exactly who does what at what time. So I really don't know the
Is there
answer.
a possibility or a risk that it would, I mean, this is,
There's a possibility that the.
would just go to the
yeah,
Treasury?
Sure, there's a possibility that the Treasury terminates the Citibank accounts, terminates the financial agency agreement, and Citibank says, fine, we're sending the money back to Treasury, and then plaintiffs
I
will
mean, is there
sue.
something that's supposed to happen? And I know that agreement is sealed, so I don't want to, if we can't talk about it, we can't talk about it, but is there something either in the financial agency agreement or principal pools of law that you're aware of as to what happens to money like this when?
The financial agency agreement says that if in the event of a deobligation, like a termination, that the Citibank has to follow the directions of Treasury consistent with the account control agreement. So it cross-references another agreement. That, by the way, is at 2148 of the JA. But I really can't predict exactly how it's going to play out after remand. All I can say is we never got to any of that because of the injunction, and the injunction is erroneous.
So the government, and if you can't make a representation that it would not, Citibank will have to make its own decision, but the government would not move those funds, do anything with them until at least resolution of the closeout process.
I don't think I'm authorized to make the representation. I don't know if a decision has been made. I do know that the decision was to proceed with closeout, and we've always been ready to proceed with closeout. And the money is there. I think the money is there regardless of exactly where it's housed. I mean, they can't spend it in the Citibank accounts if the grant is terminated, but it's there, whether it's there as an agent of Treasury or in a Treasury account. in Treasury's hands. It's there for closeout purposes, and we are committed to undertaking closeout process expeditiously. And if there are
So sorry,
disputes,
if it gets moved to, and really, this is uncharted territory for me at least. If it gets moved to Treasury and they go through the closeout process, and it turns out under the closeout process, they actually get to keep the money that was left in their funds for use consistent with the purposes under which it was originally given. Treasury would then have to, I mean, is this judgment fund? I'm not sure what this is. Would have to then give them back the money?
Your Honor, that's how it generally works in grant termination. So usually the money isn't in Citibank. Usually the money is in a government account. And there's closeout, and as part of the closeout process, they do a reconciliation, and let's say we figure out, all right, we owe them $1 million. The money comes out of that account and goes to the plaintiffs from that account. It sits there until, it doesn't get, I think, technically de-obligated until closeout is done. So it's there and available for closeout.
So it's still obligated until the closeout process is complete.
That's how the regs are supposed to work.
Can I just make sure I understand the government's view of how the cause of action, the statutory cause of action and remedies are supposed to work? Suppose, hypothetical, not saying this is what happened here. Let's suppose that in February of last year, President, EPA administrator, all of the relevant parties said, we are terminating this program and pulling back all of the money, and we are not going to reobligate those funds. Would you agree that that would violate the Inflation Reduction?
So for purposes of this case, we haven't argued otherwise because we didn't think we had to. I think the only potential point I would make is that the Inflation Reduction Act actually didn't require the money to be spent in the first place. So if your hypothetical is imagine an appropriation that is a mandatory appropriation, right? The government agency shall spend $1 billion on X, and the government says, we're not doing it, too bad. Yeah, I think there could be a cause of action.
So I understand you to be saying that the remedy or a proper injunction, if such a cause of action were valid, would be in order to reobligate the funds as opposed to an order setting aside the termination. And what is your, I guess, best authority for that proposition?
I think it's just the point that the remedy is supposed to match the wrong. So if the wrong is you're not doing what Congress said, the remedy should be you have to do what Congress said. And that is what happened in the Global Health Council case. At least the allegations were there's this money that's been appropriated for foreign aid, and State Department or USAID is not spending it. So the remedy wasn't, it has to go to the plaintiffs. The remedy, even the district court before this court's opinion, was government has to obligate it by the deadline. And I think that's appropriate as an equitable matter because to the extent that the statute affords some discretion to the agency in how to implement the program, and here the discretion was very large. I mean, the statute is short, doesn't have a whole lot of detail. These sub-programs, NCIF, CCA, was all developed by the agency. The process for picking the grantees was developed by the agency. Obviously, the contracts were developed through agency discretion. So there's no basis to take that discretion away if the problem is you're not doing what the statute wants.
Make sure there's no additional questions at this time. Thank you, counsel.
Thank you.
Give you some time for rebuttal. Mr. Allen.
May it please the court, Wynn Allen on behalf of Citibank. Citibank has a limited role with respect to this grant program. We operate as a financial agent of the United States, in which capacity we perform commercial banking and financial services to support the grant awards. There's obviously a dispute between plaintiffs and the government as to what should happen to the grant funds. Citibank does not take any position with respect to that dispute. Whatever the court ultimately decides, Citibank will comply. Our only interest is in following court orders and complying with our contracts with the government and the plaintiffs. I wanted to make two modest points in my time today. First of all, if the court does determine that plaintiffs are not entitled to an injunction against the government, then they are also not entitled to an injunction against Citibank. There's no scenario in which plaintiffs can obtain relief against Citibank alone. Secondly, we do believe Citibank has complied with its contractual obligations to both the government and to plaintiffs. There was a period of time when Citibank was subject to conflicting instructions from the plaintiffs and the government. And in that scenario, Citibank did its best to balance the contractual requirements imposed on us by the financial agency agreement with Treasury with the contractual requirements in the account control agreements with plaintiffs and EPA. Citibank believes it adhered to both contracts, and we don't believe there's any merit to the breach of contract claims that plaintiffs brought against us.
Or if the injunction lifts, either side and the contracts, assume the injunction lifts, so contracts are not reinstated, freezes off, or it wasn't already off. Don't hear boo from either party. What does Citibank do with the funds?
In that instance, the grants have still been terminated, Your Honor?
Yes.
Yeah. So
If the injunction lifts, yes.
in the event of a grant termination, what the FAA tells Citibank is that we must take direction from the relevant secured party in accordance with the account control agreements. So for the primary grantees funds, we're required to take direction from the EPA.
Yes, but if they don't say anything to you, that was my hypothetical, because they've said maybe that you would just send it back on your own.
If Citibank is not directed to do anything with the money will stay in the current accounts it's in right now at Citibank.
I thought you just said that Citibank's obligation would be to take direction from the secured party under the scenario that Judge Millett posited.
That's correct.
But the account control agreement requires Citibank to, quote, comply with all instructions, notifications, and entitlement orders that the bank receives from the account holder. That would be plaintiffs directing the disposition of funds and financial assets in the account, and may only refuse if the secured party, that would be EPA, exercises its right to issue a notice of exclusive control. So if they have done that, then, and the injunction is lifted and the agreements are in effect, and EPA says, don't. What's your,
It is frankly,
and the plaintiffs ask for money from their accounts.
it is frankly unclear to us, to be candid, Your Honor, in the event of a grant termination, whether EPA has to exercise a notice of exclusive control in order to give us directions as it's entitled to do under Exhibit A, B, 3 of the FAA, or whether they can give us those directions without issuing a notice of exclusive control. Again, as we read the FAA, we're required to take their direction as to what to do with the funds. It's not obvious to me that requires them to implement a notice of exclusive control.
But the ACA is clear. The Citibank may refuse only if the secured party under the ACA exercises secured party right to issue.
That is what the
control.
ACA says, Your Honor. But again, we are subject to both contracts, so we have to construe that consistently with the FAA. And the FAA certainly does say that we're obligated to take direction from the relevant secured party. So I think we'd have to have a discussion with the EPA and say, are you going to issue a notice of exclusive control or not? And if you're not, why do you think that we can still take your direction? We haven't had that conversation.
Is there any reason to think if the termination is upheld, why wouldn't that notice follow as night follows day?
I expect it would, but I haven't had conversations with the government about it.
My colleagues don't have additional questions. Thank you, counsel. Wrap, please, counsel now. Mr. Unikowski.
Thank you, Your Honors. May it please the court. I'd like to begin today's argument with the issue of the grantee's title why the grantees have title to these funds, and why that is dispositive as to the jurisdictional question. So EPA frames the grantee's title as a kind of technicality or maybe a kind of artifice to avoid the Tucker Act. That's not the case. The grantees have title because that's necessary for the program to work as intended. In the Greenhouse Gas Reduction Fund statute itself, both in the definition of an eligible recipient and in the definition these green banks could not really be green banks unless they're adequately capitalized, unless they can put these funds on their balance sheets so they could potentially attract private capital as Congress intended. So that's why from day one, this program was designed to ensure that the grantees would in fact have title to these funds. And contrary to EPA statements, I think that these documents are invariably unambiguous that the grantees have title to the funds. It's true that EPA has a security interest and it can exercise that security interest in certain circumstances, just like a bank can exercise a security interest on a homeowner. But nonetheless, title is in the hands of the grantees precisely so they can put that money on their balance sheets and really call themselves legitimate green banks. And so, yes,
the plaintiffs here did not say anything about the Seventh Circuit cases that were cited by the government with respect to how grant funds held by a third party are treated. And I'm wondering if you have any response to how in re Joliet Will and the other cases that were cited, which have also been cited favorably in the DC Circuit, apply for understanding. You have kind of there's sort of an abstract argument about title, but then there are all of these cases suggesting that until grant money is spent for its intended purposes, the government retains, the ultimate reversionary interest in that money. And here the money has not yet been spent for the statutory purposes.
Judge Posner's opinion in that case doesn't suggest that in every single case where there's a grant, the money title stays with the government. There's specific language in that opinion saying that it turns on the specific terms of the grant agreement at issue. And so the terms in this grant agreement are quite different than, as far as I know, the terms in the grant agreement at issue in that opinion.
Well, then that just puts you into Court of Federal Claims. Like if the claim about title is a contract dispute, then that is a dispute to be resolved elsewhere.
I respectfully disagree with that, Your Honor. If we have title, then we're allowed to proceed in district court, and the court always has jurisdiction to determine its own jurisdiction.
But the question of title you've just said is a contract question. It turns on the agreements you just said.
No, Your Honor, that's not the case, Your Honor. The court is able to decide whether we have title for purposes of deciding whether we proceed in the Court of Federal Claims. That's what the court essentially said in Land versus Dollar, which is very similar to this case. Right, the plaintiff argued.
What about the cases under 18 USC 641, which say that for criminal, you can have criminal liability for grant money held by a third party that is not yet spent for grant purposes if you convert that money? That is well established across the circuits. This circuit has upheld convictions on that basis. What is your best case for the fact that grant money before it is spent is somehow the property of the grantee? What is your best case for that? In contrast to the Seventh Circuit cases and this long line of criminal cases under 641.
All I can tell you is the language of is quite unambiguous. I don't think there's any dispute what a concept of a secured party means under a property law. Like
I'm a little confused by your answer, partly because the money has been spent for the purpose of the statute, which is to capitalize a nonprofit financial institution that's then going to leverage private investment and provide a catalyst for development of clean energy infrastructure. Has it not, in the sense of dispersing obligated funds, been spent for the purpose for which it was intended?
I agree with that, Your Honor. The funds have already been not only obligated, but also dispersed. The agreement calls these funds capitalization by non-exchange capital contribution. So the banks have been capitalized. The money has all been spent. So I don't
grant
really...
money is treated differently under our case law as to who has the reversionary interest. So can you point to any, there are so many cases that say money in this circumstance remains the property of the government. So if your situation is obvious, can you point to a case involving grant funds where the title goes to the grantees before it is spent?
I don't think I have a case because I don't think that there's been a situation like this where there's been green banks which have been capitalized and the money already has been spent. I don't mean to talk past your honor, but I think all of the money has been spent. It has all been dispersed. These banks have been capitalized.
It's sitting in a bank account, right?
Yes, your honor.
And in at least one respect, this is a tougher case for the grantee than Joliet. In Joliet, the funds were in the bank account of the grantee.
Yes, your honor,
Or it
but
says it's still property of the government, taking into account the substantive restrictions on the grant and here, same restrictions, except it's one step removed from the grantee. It's not in their bank account.
your honor, even setting aside the grant agreements,
It's in a sort of like an escrow-like arrangement with Citibank.
that's not the case, your honor. From day one, from the notice of funding opportunity, EPA made clear that the funds would be dispersed at the outset so the banks could be capitalized, so we could lawfully put all of these funds on our balance sheet so we can attract private investment in accordance with Congress's intent. There was just nothing like that in the bankruptcy case at issue in the Joliet case. And even wholly setting aside the grant agreement, the ACA itself explicitly says that the pledgor, that's the grantees, is the customer, it's the entitlement holder with respect to the financial assets. And then the agreement says it's intended to, quote, perfect the security interest of the secured party. That's a commercial relationship between us and Citibank and EPA. And I just don't think it's possible to read this language and hold anything other than title in the property is with
It
the
also says
pledgors.
you will grant the security interest to EPA. I'm not sure how you can grant a security interest in something that's not yours.
That's exactly right. So, I mean, I understand there may have been other cases and other grant agreements that don't involve the capitalization of green banks that have to put money on their balance sheets in order to attract private investment. But I would repeat that the Joliet case, yes,
The case law in a variety of contexts, and this is kind of a strange fact situation. I understand it's somewhat sui generis with these grants, but the reasoning of those cases is that where the government maintains supervision and control over the grant money, before the grant money is spent, it effectively remains the property of the government. And it remains so even for the purposes of criminal liability for conversion of those funds. And here under the accounts, EPA maintains a great deal of supervision and oversight over these funds. You know, the grantees can't spend the money without EPA approval. Disbursements have to be approved. There are a whole list of ways in the agreements in which EPA maintains supervision and control over the funds.
Your Honor, I don't think you'll find a single case anywhere that says that someone could be a secured party and nonetheless maintain title. That's just not what it means to have a security interest in something. And all of
I don't think you can find it. You have said that there are no cases suggesting that grant money is treated in that same way because grant money is a unique type of disbursement. It remains the property of the government. And you've not pointed to anything that gets out of that basic principle that was established in the Supreme Court case, I think from the 1850s.
The Supreme Court case in the 1850s doesn't involve the actual capitalization, which the EPA explicitly says that it's handing over all the money to capitalize these organizations.
Handing over the money, but the money hasn't yet been spent for grant purposes, and the EPA maintains a great deal of supervision and control. In that circumstance, this, even if nominally the grantees have some kind of title, it's not title that matters in this context.
Well, I think it is title that matters in that context because I think it sharply distinguishes this case from cases such as DOE and NIH, where the plaintiffs really were trying to get money out of the Treasury. I think that's a helpful way of thinking about the Tucker Act preclusion issue. So as I read the DOE and the NIH cases, the plaintiffs were trying to get money directly from the US Treasury. That's what they were trying to do. And the Supreme Court, as I interpret those decisions, were saying that the Tucker Act provides a way for you to do that. If you want money from the Treasury, go to the Court of Federal Claims and you can get your money from the Treasury pursuant to the grant. And so the Supreme Court was saying you can't go to federal district court to get money from the Treasury, which is what you want, which you can already get from the Court of Federal Claims. In this case, we're not asking for any money from the Treasury. There is no money from the Treasury that's even at issue. The relief we're asking for, which is preventing the interference with these funds that are in the accounts with our names, with EPA holding a security interest, is completely unavailable from the Court of Federal Claims. That's why I think that the grantees legal relationship to these funds is dispositive in this case. Just thinking functionally in terms of the remedies that the Court of Federal Claims is even capable of giving, it can't even possibly vindicate our claims to these funds in this case.
I'd love it if you would address the statutory claim, which was discussed a little bit in questions to Mr. Roth. The panel held that EPA did not violate the Inflation Reduction Act when it terminated the grants. And I think that the crux of that statutory holding is the panel's rejection of the district court's fact finding that when EPA acted to terminate these grants, it had no intention of obligating them. Now, I know that it seems like that was addressed more. I know I thought about it more at the panel stage as whether it was a violation of the Appropriations Clause, whether it was the executive infringing on Congress's Congress's constitutional power to direct appropriations. But there's really a simpler version, isn't there? And it's not the APA arbitrary and capricious, but the APA contrary to law, i.e. contrary to the statute. And so why isn't that the simplest way to resolve this case if the court were inclined to resolve it in your favor?
Sure, Your Honor, we'd have no objection to the court resolving that case this way. We think there's both a statutory and a constitutional violation, but I'm happy to focus on the statutory violation. And I agree, if the court concludes there was a violation of the statute and that there's jurisdiction, that would be contrary to law.
And to conclude that, we'd have to think that the appropriation was mandatory in the sense that the executive had to spend it.
I think so, but that's not been disputed at any time by EPA in this case. And there's cases like Train which reach that conclusion.
And they say, well, there was nothing saying it had to go to these recipients. True enough, but it went to them.
That's true.
And if it went to them and EPA is trying to get the money back after the appropriation lapsed, and it has identified no authority to reobligate, and indeed it now disavows, I think wrongly, authority to reobligate, and it had, as the district court found, no intention to reobligate. Why aren't those just the ingredients of a straightforward violation of the IRA? Like, why do we need to get into Tucker? Why do we need to get into Dalton?
I think that would be a very straightforward way of resolving the case. And I just add one more point onto the table, which is I agree with the way Judge Garcia formulated the remedy, which is if there's unlawful agency action, then the natural thing for the district court to do is set aside that unlawful agency action. Certainly in the district court, the government didn't suggest any other injunction other than setting aside the action. So I think that the district court did the ordinary thing one would do in this situation, which is identify a violation of law and set aside the action that resulted in that violation.
What the action is, the terminations?
Well,
Yeah.
I understand it to be the dismantlement of the entire program, which was effectuated through the terminations, and also the unlawful infringement on the property interest held by the grantees, which was again effectuated by those terminations. I think that's the right way to think about what the government did here. There weren't like targeted, isolated terminations. It was really the dismantlement of the entire program.
Mr. Unikowski, can you point to where in the complaint there was an argument that the dismantlement was contrary to law under the APA? Because I don't see that anywhere in the complaint, and I don't see that anywhere in the injunction that the district court actually issued in terms of the APA relief, which is all based solely on grant terminations. This is a nice, it's an interesting repackaging now, but I don't see where any of that was argued below.
Your Honor, I respectfully disagree. I think this has been our claim the whole way. So
Okay, so
JA
then-
327 is our preliminary injunction motion. And in our section, the portion of the brief talking about the arbitrary and capricious argument, we say, indeed, it is clear that the vague references to lowercase fraud, waste, and abuse in the notices are pretextual cover to shut down a program approved by Congress that the new administration does not like. And likewise, in the section about the Tucker Act, one of our core arguments is that this wasn't really an individual termination case, that ultimately the EPA had shut down the entire program.
But
And
the
I think
shutdown arguments are made under your constitutional separation of powers claims, not under the APA.
No, Your Honor, what I just read to you was in the portion of our brief addressing the APA claim. And I also understand the district court's order to have understood our argument correctly and resolved this issue. So you'll see on page JA 993, the district court says, though repeatedly pressed on the issue, EPA offers no rational explanation for why it suspended the grants and then immediately terminated the entire NCIF and CCIA grant programs overnight. And
Well, but that is linking, that is suggesting that the termination of the grants are coterminous with dismantling. And your argument is that there is a separate contrary to law claim for the dismantling.
well,
I
I
mean,
phrase
this
it,
is a little bit of a different case than, say, the NIH stay case before the Supreme Court, where at least Justice Barrett explained that the guidance was distinct from the grant terminations. Here, any dismantling is solely about the grants. And is there any program beyond the grants here? I mean, Section 134 is just about grants. There's no additional program other than the grant terminations.
I'd word it a little bit differently. What I understand EPA to have done is terminated the program by simultaneously shutting down all the grants on the identical ground. So I think that you can't really view EPA as having done 8 separate things here. EPA really did one thing, which is dismantle the program. And it effectuated that dismantlement by sending these word for word identical letters to all of the grantees at the same time. And so, in terms of thinking about whether there's been a violation of the statute, I think there was. And I think you can see this in kind of 2 very related ways. So one, as the court knows, every agency must point to statutory authority for everything that they do. An agency can never act, has no power to act unless there's something in a statute that allows them to do it. And so if you agree, as the district court concluded, that EPA was dismantling this entire program, it needs to find some statutory authorization to do that. And there's certainly nothing in the Greenhouse Gas Reduction Fund that says that they can. The GGRF says that the agency has to make grants. We do think that's mandatory by September of 2024. And then it has some requirements for the grantees. But there's no affirmative statutory authority to undo and redo the program after the date. And if you accept the district court's factual finding, and I don't see the government as having argued that that's clearly erroneous, the practical effect of the dismantlement is going to be to wipe out a program that Congress declared to be mandatory. And I do want to say one other thing about.
I'd like to
Yes,
just
Your Honor.
press you to make sure I understand what you just said. It's your contention that if a statute says that funds have to be spent by X date, then the executive cannot terminate the program after said date because that would violate the statute.
Correct. So,
what's your authority for that proposition?
well, let me say it in 2 ways. One is that the agency has to have authority to do everything that it does. And there's no authority, positive authority, to dismantle the program after it's already been fully dispersed. So that's one point. The EPA has never pointed to any authority to redo the program. And second, I think that this statute contemplates that once the grants are made, they won't be just immediately unmade, thus putting the agency into the position it would have been if it had never made them at all. Like EPA's position seems to be that if on September 30, 2024, all of the grants were made, and then the next day, the program was just completely dismantled, that EPA would have complied with the statute simply because the grants were made, even though they were unmade the next day. And that can't possibly be right. This statute presupposes that the program will not be shut down, that once it is put into existence, it just won't be eliminated. And so I do think there's a statutory violation where EPA wipes out the program, putting the parties in exactly the situation they would have been in if it had violated the statute by never having made the grants at all. So I think that's the simplest way. That's the way I understand it.
But I thought that the posture in the district court and before the merits panel was that the statutory violation was not just terminating, but also without reobligating.
That is correct, Sean.
That the real core of the violation was, well, you're just trying to not spend this money. And so maybe you could terminate, but if you terminate, you've got to reobligate. And we don't believe that there's any intention of reobligating, so that's the violation. I thought that that was the argument that was made below.
That's right. And the district court made a factual finding that this dismantling was going ahead and that the representations in court about reobligation were inconsistent with the record.
But I guess I'm trying to, forgive me. I think about these things like a trial judge. And I tried to think of what is the cause of action and what would be the elements of the cause of action. The elements of the statutory cause of action is no intent to reobligate the funds an element of the statutory cause of action, yes or no?
I don't think it is. There is a factual finding, but I don't think it is. If I can explain that and answer you one. So EPA said that it asserted it was going to reobligate the funds, but EPA also said that it had these dramatic programmatic concerns and it wanted to reobligate the funds in this completely different way. It's never specified how it would do it, but it made clear that it was going to reobligate the funds according to a program that was radically different from the original program. If it did that, that too would violate the statute, because any limited authority to obligate funds after an appropriations deadline has to be pursuant to substantially identical grants. So really, EPA had two options. There's two options on the table. One is that, as the district court found, which was not clearly erroneous, they weren't going to do it at all. Or number two, even accepting everything EPA said, they were going to reobligate in a manner that would also have violated the statute. So either way.
Which statute?
What's that?
When you say they would have to reobligate in a manner that's substantially identical, is substantially identical coming from the IRA/GGRF, or is that coming
No,
from somewhere?
that's a general principle of appropriations law that the Comptroller General has applied. And the statute creates a deadline of September 30th, 2024. There is some authority from the GIO that if you're going to give a substantially identical grant, it's like a continuation of the original grant and sort of like nunc pro tunc. The date of the grant will be deemed to have been before the deadline. And that's how, in very unusual cases, the GAO has authorized the reobligation after a statutory deadline. But other than that situation.
So it's the statutory deadline that's doing the work then. I'm just trying to figure
Yes,
out.
the statutory deadline is doing the work, because if EPA completely redid the program after the deadline, that would violate the requirement that the funds be obligated by the deadline. So, I mean, I think the easiest way to resolve this case is just to say that the district court made a factual finding that the funds weren't going to be reobligated, and EPA has not argued that that's clearly erroneous, and the court can just end the analysis there. But if the court were to decide to credit all the representations that the funds would be reobligated according to some completely different scheme, that would just be a different type
I'm
of
trying to
statutory
understand
violation.
what work the finding that the EPA had no intention of reobligating funds. What work does that finding do? You just told me that it's not an element of your cause of action, so who cares? I mean, why has so much ink been spilled on that in the briefing before the panel, briefing before the district court, briefing before us, briefing in the panel and dissents? You're telling me that that finding doesn't matter for your claim. Is that right or wrong?
I think it matters because it establishes that EPA necessarily was going to violate the statute. You see, we're willing to accept for the sake of argument that.
But your argument is that the statute was violated the moment that they terminated after the statutory deadline.
So
Isn't it, let me see if I can, you can
I'd like
repudiate it.
for him to answer my
Yeah,
question.
I'm just gonna, okay,
I'd like for him to answer
Yeah.
my question, as I asked.
okay, let me answer the question. So we're willing to accept for the sake of argument that if EPA had complied with the requirement to give substantially identical grants, which it clearly wasn't going to do because it says it wasn't going to do that, but if EPA had complied and issued substantially identical grants, then under these GAO cases, that might not have been a statutory obligation. But we know it wasn't going to do that because there's a factual finding that it wasn't going to do that because it was going to terminate it altogether. And then even accepting everything that EPA said, it was going to give completely different grants. So that's how that's the only slight modification to your question about terminating after the deadline. These GAO authorities say that there's this very unusual exception for substantially identical grants, but we know that EPA wasn't going to do that. I'm sorry, Judge Pillar.
I guess I had been thinking about, and your answer was not surprisingly more nuanced, but I had been thinking about them as almost belt and suspenders, that either EPA has just determined it's not going to spend the money, or the district court has so found, and or it can't anyway. It says we're going to re-obligate the money, and then it kind of looks around and it says, yeah, there's a replacement grant. and says, that's what we're going to do. And you're right that replacement grant is this very, very narrow authority, and they haven't pointed to any other authority. So again, it's sort of, that's the suspenders on the district court's finding that they never meant to anyway. So it's like they never meant to, they didn't have any authority to, so that backs up what the district court found.
I think that's probably a better way of putting it than I did. I mean, when EPA terminated the program, it just terminated it completely. And then this notion of reobligation sort of came up after the fact in an effort to try to retroactively justify EPA's
I
actions.
thought they referred in the termination letters to reobligation.
Well,
and that is actually not really available. It's not really reobligation, it's a replacement grant. So it's considered the original obligation, as you said. So yeah, it's sort of both. I think that was post hoc, but they did in the letter.
right. Well, there's certainly no indication contemporaneously that EPA was going to comply with the statutory requirements of the IRA by giving a continuation grant. That was never asserted. I'm not sure it's ever been asserted at any point in this case that EPA was going to comply with that statutory obligation.
But the statutory deadline is essentially a statutory mandate.
Yes.
And so you wouldn't be able to reobligate after that time period.
Correct. I mean, setting aside this very narrow exception for continuations, they would have had no authority to do that. So EPA's purported plan of setting up an entirely new grant program after the deadline is plainly contrary to law, which sets a deadline for September of 24. That's why I think that the easiest way to view this issue is to say that EPA needs statutory authority to do everything that it does. And it doesn't have the statutory authority to undo and redo the program after the statutory deadline. Yes, I'm sorry.
I'm interested in how this, I understand your theory of the statutory violation. How does that theory persist after the Repeal Act? Because for the constitutional claim to work, it rests not on the terminations, but it rests on this idea that the government won't reobligate the grants. So even even just accepting the district court's finding that they're not going to reobligate the grants, that whole circumstance has arguably changed now that Congress has said this program is over. We've shut down the program, not just with respect to the money, but respect to the budget authority and the statutory authority for reobligating the grants. And I didn't see anything in plaintiff's briefs accounting for how that change in circumstance can allow this court to uphold the preliminary injunction, which is based on this idea that they were dismantling a program that was required by law. Even if they were intending to, dismantle the program, that program no longer exists. So I don't see, so what is the best argument that your so-called separation of powers or statutory claim persists after the repeal?
So, Your Honor, I think the right way to look at this is to ask two questions. First is, when EPA did the thing that it did, was it lawful? And then second, did the passage of the One Big Beautiful Bill Act change that? So, I'm sorry, did you have a follow-up question? So, we have, as we've argued at length in our briefs, when EPA did what it did and when the district court issued this injunction, EPA had violated an act of Congress. EPA had acted without any authority. It had shut down a program that Congress had authorized. We have argued that that's a separation of powers and a statutory violation. So the question is whether the subsequent passage of the OBBBA should alter the legal analysis with respect to EPA's prior action.
Well, so I take your point with respect to the grant terminations, right? So grant terminations, you've argued, were unlawful, for a variety of reasons. That is backward-looking action as to, whether those grants should be restored. But as to the separation of powers argument, with respect to upholding a preliminary injunction, which is forward-looking, this court has to take the law as it is. And the law as it is, under what Congress passed in this Repeal Act, is that there's no longer any authority for this program. So if EPA could not reissue these grants, how could we uphold an injunction requiring them to issue new grants? Because there's no longer, as you said, EPA can only act if there's statutory authority. That statutory authority has been repealed.
So I don't agree with that for two reasons, okay? So first of all, I just point to the text of the act that I think was written to foreclose any such argument. It recites that the unobligated balances of amounts made available to carry out the section are rescinded. So it's specifically contemplating that the obligated balances are not rescinded. And it knew that at the time that the statute was passed, those funds were still obligated because there was an injunction against the termination. that
But you're
Congress-
just reading the unobligated funds part. The Repeal Act also says that Section 134, which is, the section that was created by the Inflation Reduction Act for these programs, is repealed.
But it was a prospective repeal, Your Honor. The prospective repeal of a statute doesn't retroactively render an illegal action legal. Like if there's a criminal statute and then someone commits a crime and then the criminal statute is repealed, then unless the statute specifically says it, it doesn't mean that the person's crime is excused. It just means going forward,
Well, but
the law
there
is
are two
changed.
different illegal acts. One alleged illegal act is the grant terminations. Another one is dismantling the program. That act can no longer be illegal after the Repeal Act.
Your Honor, it was illegal in the moment it happened. And a district court,
Are the grant agreements still in effect after the repeal for the already obligated funds?
yes, absolutely they are. Your Honor.
So is the answer to Judge Rao's question that it would proceed under the still existing grant agreements?
It would. That would be the effect. I mean, we're not asserting a breach of contract or breach of grant
Well,
agreement.
but then you're right back to the Court of Federal Claims. If the
No,
claims are based on the grant agreements and there's no longer the possibility of a dismantling claim because Congress has by law dismantled the program, then where does the, constitutional claim come from? There
I
is
don't-
no longer that justifies a preliminary injunction, which is a forward-looking restriction on what the government can do.
Right. It's a forward-looking restriction because the government's prior illegal action doesn't become legal by virtue of the statute because the statute doesn't purport to alter the legal
Well,
status. of the
it could.
government's
So, I
actions in
mean,
the
a
past.
statute could do that.
It
And
could.
the question is whether this one did. And I guess as an adjunct to what Judge Rao was asking you, so the statute says Section 134 of the Clean Air Act is repealed. And then it goes on to deal with the unobligated funds. What is your interpretation of the is repealed part? What did that do? What work did that do, if any, independently of what followed?
So I don't really think it did much work at all, but to the extent that any work, it's possible that it had the effect of eliminating certain statutory requirements on grantees. So there's a part of the statute that sets forth certain obligations. That's A, to issue grants by September of 24. And then there's various requirements about the use of funds, B, for eligible recipients that go forward. So I suppose you might say that the repeal got rid of B on a forward-looking basis, certain requirements for grantees on the use of funds. Of course, the contracts themselves already have a set of requirements, so that actually didn't have much of a
Why
practical
would
effect
it,
anyway.
even under your theory that the grants are governed by the statute that was on the books when they were awarded?
So I think that's the best interpretation. I mean, if you want to give the repeal some meaning, that's might be how you give it. But I do think that the best way to look at this is that the repeal was sort of belt and suspenders.
I don't know if you had
Yes.
two answers. In answer to Judge Rao's question, and we kind of took you off track, as is our want. I apologize. But she had said, you have to take the law as it is, forward looking. There's no longer any authority of this. How can there be a statutory violation of the IRA and or a constitutional claim? And you said you have two reasons. One, obligated balances, only the obligated balances are rescinded. And I don't think we let you get to your second.
Okay, I guess my second was that you should read the two parts of the statute together. So there's the repeal, number one, and then there's the unobligated balances of the amounts made available to carry out that section, number two, are rescinded. And I just think the sensible way to look at this is to say that the repeal is connected to the rescission of the unobligated balances. And so, I'm sorry.
Go ahead.
Okay, so, the statute was taking a snapshot in time, so looking on the day the statute was passed and saying, okay, if there are funds which have not been obligated, which there were some administrative costs that weren't obligated, those funds are rescinded. And I guess with respect to those funds, the statute doesn't have any forward-looking effect. But it didn't purport to rescind the obligated funds, even if those funds were deobligated afterwards. Those, as a question from the bench in the first half, those would become orphan funds unless the statute still applied to them going forwards.
It's interesting to me that Congress did only what it did. I had the impression that that Congress felt like it couldn't. It would be really extraordinary for it to rescind funds that had already been spent. Is that something that you've that you know anything about or can help us think about?
I mean, it would have been extraordinary. It would have exposed Congress to litigation. You know, there would have been takings claims, other types of claims. I mean, if Congress had enacted that statute, it would have been very legally vulnerable. And so I assume that whoever was advising, whoever drafted the statute said, you know, don't do that. Make this a very narrow targeted appeal and don't purport to interfere with these already obligated funds. And so Congress didn't. It was very careful to avoid that outcome, which is why we're here making the same arguments as we would have made before the repeal, because I think the best reading of the statute is that Congress just didn't want to touch the legal issues that would come into play if it purported to issue some kind of retroactive
What if,
repeal.
EPA had taken the same actions it did here, but it did them the day after Repeal Act? It issues a notice of termination across the board to everybody. Says, and you keep throwing some statements about we're getting rid of this program. Congress got rid of it and we're happy to get rid of it. How is this, what's supposed to happen going forward? The money's in the accounts. But provisions, I mean, does the supervision by EPA end? Does the EPA have to keep supervising and authorizing, I guess, withdrawals more than, I think, 10% of the award? Does a court force the EPA to continue that supervisory role? I'm trying to posit in a real world way how we're supposed to navigate this forward-looking relief going forward post repeal.
Well, I think there is no way, which is part of the reason the court shouldn't construe the statute to have had that effect on the separation of powers claim, right? Because
I'm sorry, there is no way, or is it?
no,
I'm sorry, I just didn't hear what you said.
I don't think that like the relief that Judge Rao postulates, some kind of relief that sort of treats the separation of powers analysis as having changed, would really make sense in this case. So to answer your question directly.
Oh, I'm sorry, my hypothetical was it never happened beforehand. It only happened after the repeal.
I see.
And you would still say it's a separation of powers problem?
Well, if it happened, I would probably still say that because the statute still says the unobligated balances of amounts made available are rescinded. So I would say that there's probably a violation of that provision because those amounts weren't rescinded by the statute. In terms of maybe the separation of powers argument would be harder because you have to analyze the action on the date that it occurred. And so on the date that this action occurred, the statute was still in place. So, you know, I probably would still make the separation of powers argument because I think the best construction of the statute is that the repeal applied only to the unobligated funds.
But a district court issue an injunction saying, so you've done all these notices of termination that says it's here, you cannot effectuate those notices of termination?
I think we probably still make, I think our argument would be harder, but we'd probably still make the same statutory and constitutional claims because we wouldn't interpret this repeal as affecting the backward-looking grants, if in your honor's hypothetical.
But so I think it has to be the same. I think your argument would stay the same regardless of when the terminations occur. But if the unobligated balances are gone, we're meant to deal with the agency's funds for administering the act. Which as I understand it, that's what's really at issue. That's the 19 million that's in the estimate. Then there's nothing left with which to administer the act going forward.
I disagree with that, Your Honor.
Okay,
EPA gets
and that's because
$3 billion of general appropriations to monitor all of its statutory programs. I think it has abundant statutory authority to use that general appropriation to engage in it, whatever monitoring it thinks is appropriate. So, no, I don't think that EPA's hands are tied with respect to oversight.
Clarify, I mean, the assumption here is that the repeal of the unobligated funds was administrative funds. If Congress had said expressly, we hereby repeal or take back whatever the right word is for the unobligated funds that would have been spent on administration of this program. I just don't know enough about this sort of law. It would be okay for EPA to say, that's okay, we've got other funds over here that we can use to administer, even though Congress said, we're taking back money for you to administer this program.
I think EPA could do that, yes. I think that EPA has a general appropriation, which it can use for oversight of all of its grant programs and all of its functions. And I think that EPA is allowed to use that general authority and allocate it however
would they
it wants
have to? So you think EPA could tap into other funds, but do you think that EPA would have to, with respect to grants that are terminated after the repeal? Or do you think it's discretionary?
I think it's ultimately discretionary. I mean, we're not asking for an injunction forcing, EPA to continue monitoring us. That's, we're not asking for specific performance of any monitoring requirement. Even, if you can even call that a requirement in these agreements. So, I think that EPA has abundant authority to exercise whatever oversight function it wishes. And so there may be a world in which EPA just systematically refuses to, do things under the agreement, which might result in a breach of contract or potentially a separation of powers problem. But I think it's important to recognize that we're not really asking EPA to do anything at this point other than not interfere with our property interests in the contract, right? And not dismantle the entire program. We're not asking for any specific performance of any particular contractual obligation in these grants. We're just saying to EPA, don't dismantle the entire program and don't interfere with our proprietary interest.
What's the difference between that and going through the closeout process, which could leave this money in your account just the same, it'd be your money. So go through the closeout process. I assume you intend to satisfy all of its requirements, and it will be your money.
Your Honor, we think that probably would happen, but we don't think it makes sense to do that. I mean, EPA has this argument.
If so, you could go through the closeout program, and I assume your view would be you would be able to comply with all of its requirements such that the money would remain yours. The money in the accounts would remain yours, and then it would be free and clear at that point, at least of supervision. I think the obligation to still comply with the statutory purposes would go forward. Why isn't that sufficient, if not even better for you?
If that is the outcome, obviously we will accept that is the outcome.
I'm not asking whether you'll accept a rule. I'm asking you to understand why that, given there's been this repeal, why that isn't what should happen next. And maybe the funds stay frozen so neither party can do anything with it until the closeout process is done.
I just don't think it's logical as the matter of the sound administration of the courts to untether the termination and then the infringement on the property interests that may or may not happen depending on EPA's decisions pursuant to that termination. Like whatever Congress meant in 702, I don't think it intended for like one challenge to the termination to be parked in the Court of Federal Claims and the other to be in federal district court. We just don't think that's the way to run the judicial railroad. And so that's why we've argued that all these.
It's just sometimes that is what happens with Tucker Act claims. Contract claims go there and district court claims stay in district court. So there's nothing contrary to that, but I'm really just trying to get to this injunction, which was written at a time fair to the district court, obviously, when it was a different world. But now, I think we agree that they don't have to engage as a matter of statutory law post-repeal in effectuating the agreement. And step in our view is we're going to issue a new notice of termination. The injunction only applies to one with a certain date on it based on the repeal. And let's do the closeout process. Either everyone agrees, we won't touch the money, it'll stay frozen there until we finish that process. What's the problem with that scenario? I'm just having trouble understanding what the problem is if I'm reading the closeout process accurately, which could be a problem for you to point out, you end up with the money at the end.
So we definitely think Your Honor has read the closeout provisions accurately. We haven't argued for that. We've argued for an injunction against the statutory violation because, I think that our client is committed to following the statute and the statutory program. And we're not looking for.
What does it mean to have an injunction not to get rid of the statutory program? So that, are you reading this injunction as then obligating, I don't see this in the words of it, obligating the EPA going forward to continue working with you all under this program, I don't know, having meetings, obviously signing off on 10% or dispersals that reduce by 10% or more than 10%, whatever that rule is. There's rules on the size of dispersals they have to sign off on. That
we've never asked for any of that, Your Honor. I mean, we're not asking.
Right, so that's not in the injunction here. So
no, because we've never asked for that. This is not about, we're not asking for EPA to do anything. And we have, none of the grantees have asked for these additional dispersal authorities.
So if you don't want them
or-
to do anything, you want the closeout outcome.
I don't think we do, Your Honor, if that's.
Okay,
ultimately
this is
the
what
rules-
I'm missing is the delta between what you want and what the closeout agreement would get you. What is that delta?
I mean, EPA has said in its brief that if there's a closeout, it will take the position that it will sweep all the money back. And it has characterized the contrary position as implausible, even though I think that Your Honor is correct that the plain text of these agreements would require that outcome. Okay, but certainly.
I know, but that could be if the funds stay frozen, then that could be, you'd go through it and then that would be a head-on contract dispute. That, again, money could stay frozen until that's resolved, is it not?
All I can say is that the injunction that the district court entered, I think it was lawfully entered, and that's the injunction we're asking for on appeal for the court to affirm. So if the
But
court
otherwise,
agrees-
there's no practical delta for you between what the closeout process would get you and assuming the money can't be swept away, although the position is you could get it back in if you win your contract claim anyhow.
Well,
there
if
is
the
no
closeout
delta.
occurs, then there's no more grant agreement. I mean, that's, it's different. I mean, it's true, we'd still have to use the money for certain purposes, but it wouldn't be an identical outcome.
But identical isn't, lack of identical isn't irreparable harm.
Right, Your Honor, but look, I mean, EPA will certainly take the position.
Must be a reason you're resisting what I'm
Look, Your
proposing.
Honor, I mean, if at the end of the day,
Mhm.
that the court decides that the correct way to do this is for like half the case, like the challenge to the termination, to go to the Court of Federal Claims, but the district court still has the authority to issue an injunction ensuring that the funds stay with the grantees. Obviously that would be an outcome that we would accept. I mean, that would be legally correct, I think, if the case, if as the government suggests, you have to divide up the case in that way. But, we've never asked for that.
Mhm.
Because, we think that the whole challenge should be heard as one unified whole, and the district court had the authority to issue the injunction that it did, and that's why we're asking the court to affirm the injunction.
Why is it not in indicium that this is a contract claim that belongs in the Court of Federal Claims, that part of the relief that the district court granted was to reinstate the contract?
So I think it's not an indicium of a contract claim because I view that as the relief to ensure that the statutory and constitutional violations didn't occur. So I think the way to think about it is first, what's the statutory or constitutional violation? And then what's the remedy for that? So, for example, we argue that there's a violation of the IRA, or we argue that the agency acted arbitrarily and capriciously. That's a statutory violation, not a contractual violation. And that opens the door for the court to issue a form of relief that will ensure that that violation is remedied. And in this case, the court concluded that the way to effectuate that was to issue this prohibitory injunction against the dismantling of the whole program for what we argue is an arbitrary and capricious reason. But there's no authority that suggests that the mere fact that the court issues such a remedy is just a sufficient basis to eliminate jurisdiction, right? I mean, I think that the NIH case is a lot narrower than that. The NIH case does say that.
Judge Rao had
I mean,
asked you.
then prong two, sorry.
Mhm.
Then prong two of Megapulse is doing no work.
No, I don't think so, Iwan. So there's two prongs of Megapulse. One is the relief requested.
You're saying you can go to district court no matter how quintessentially contractual the remedy is.
No, that's not.
Literally reinstating the contract, and that doesn't trigger Megapulse.
So I think that the second prong of Megapulse, in terms of the relief that's requested, is directed to figuring out whether the relief you're asking for is relief that the Court of Federal Claims can give, which is to say money from the government. I actually think that the Supreme Court's articulation of that in the NIH case is quite helpful. The court says, I'm just reading from the Supreme Court's order in the NIH case, the Administrative Procedure Act's limited waiver of sovereign immunity does not provide the district court with jurisdiction to adjudicate claims based on the grants, that's one, or to order relief designed to enforce any obligation to pay money pursuant to those grants. That's two. So we're definitely not asking for enforcement of any obligation to pay money pursuant to the grants.
Court of Federal Claims can't give specific performance on a contract.
That's true. So I think that's
specific performance on a contract is heartland, prong to Megapulse pointing you in that the direction of that court.
I agree with the court that we could not have come to district court in this case and said, Your Honor, there's been an API violation because there's been a violation of the contract. In other words, we couldn't have said that a contract is a type of law, it's private law, and therefore, because The agency has acted contrary to that private law. It's acted contrary to law under the APA, and therefore the correct remedy is to order specific performance of contractual obligations. That, I agree, is a claim that's based on a contract when the legal right that's being asserted is the right to have the contract followed. But that's definitely not our claim. We've never said that. We've always argued a constitutional claim, a statutory claim, and a regulatory claim, and therefore it's not based on a contract within the meaning of megapol. So I do agree that specific performance is improper when the claim is founded on the contract in the sense that the source of law that was violated.
I take your point on prong one. You're invoking public law sources,
Yes.
APA and IRA and maybe the Constitution. But in order to produce a remedy that to me seems like totally heartland Court of Federal Claims on prong two.
I don't think it is. So let me just say two things about that. So first of all, I think Heartland Court of Federal Claims is a money judgment because that's the remedy that the Court of Federal Claims is empowered
Yeah,
to
fair
give.
enough. But so is specific performance is pretty close to the heartland.
No, I mean, I think that when we think about prong two, the way I think about that is that the court should figure out whether the relief that's being sought is relief that would be available in the Court of Federal Claims. And if so, that may displace the district court's authority. But here, the relief we're asking for is clearly not available in the Court of Federal Claims. And so it doesn't displace the district court's authority. I also take issue with the idea that this is specific performance of the grant. I think there's a difference between blocking the government from taking an action that has the effect of dismantling the program and interfering with their property interests and specific performance of a specific contractual obligation. Again, like this is a prohibitory injunction that doesn't force EPA to really do anything. It's interesting in the reply brief, and the EPA says, well, the reason this is specific performance is that there's some scenario in which EPA would have to approve some action that is inconsistent with the EPA approved work plan. Yeah, but none of the grantees have asked for that, and the district court's order doesn't order EPA to do that. So I don't think that this is really reasonably characterized as specific performance of a particular term. I think it's a prohibitory injunction designed to enforce compliance with the statute and the APA.
Can I ask a question about this? So the result of what I'm going to say is that, as Judge Katsas was suggesting, the first prong of Megapulse really drives the train. It seems to me, although Ingersoll Rand said something else, we've also said this, Trans Ohio, Sharp, written by Judge Scalia, tells us a district court may accept jurisdiction over a statutory or constitutional claim for adjunctive relief, even where the relief sought is an order forcing the government to obey the terms of a contract. That is specific performance. Our cases have always, I mean, has something from this court or the Supreme Court overturned our fairly simple approach that if your claim is truly based on a statute, you can get relief that looks like specific performance of a contract?
It has no, I think that prong two, as elaborated in DOE and NIH, is ultimately about money from the US Treasury. There is this, I mean, I do understand the Supreme Court have said in DOE that if the plaintiff is asserting an arbitrary and capricious breach of a contract that provides for money from the US Treasury, and the remedy that the plaintiff seeks is money paid directly from the Treasury pursuant to a grant, then perhaps that claim goes to the Court of Federal Claims because that's the court that has.
And then I just have another clarifying question
Yes.
about what has been enjoined and what we are reviewing, because I think it would sure be a problem. This repeal would be a big problem for you if the government was enjoined on an ongoing basis from terminating the grants. My understanding is that that is not the injunction and it never has been. And they could have terminated your contract for better reasons on March 12th. They could have terminated it the day after the repeal and you would have raised other challenges. But all that's in front of us is a order saying not to effectuate the March 11 termination notices. And
I think that's correct, Your Honor. I think all the district court did was the classic APA remedy of setting aside a discrete unlawful agency action. So if the EPA wants to do something else going forward, I'm sure we'll have more litigation about that. But I don't think that the EPA's action is anything other than, invalidate unlawful agency action. Of course, if the EPA tries to get around the injunction or does something else, we might have additional litigation.
But we have to consider whether it was lawful in light of current law.
Well, the court always considers current law, but current law may include like looking backwards and finding that the current law is not retroactive. So I think so again, in a criminal case, suppose a statute's repealed, a criminal law is repealed and someone is indicted before the statute. Okay, so the court always looks at current law, but current law includes the effect of the repealer. And if it didn't repeal going backwards, the person can still be criminally charged. So it's kind of the same thing here. Like, obviously the court always has to look at the US code in front of it, but if the statute is not retroactive, and it clearly isn't, it just says repeal, it has nothing about retroactivity, then the unlawfulness of the EPA's action wouldn't be rendered lawful by virtue of a forward-looking repealer statute.
Can I, let's suppose here, the government back in February or March said, terminating all these grants, we're going to issue replacement grants, and they lay out precisely when and how that is going to occur. And you file a lawsuit challenging that as violating the Inflation Reduction Act. Does that violate the Inflation Reduction Act?
If there fell within this very narrow exception for replacement grants that were simply a continuation of the original grants, then I'd say probably it wouldn't. But that's not what happened. That's not what the district court found.
I understand that's not what happened, but it gets back to my question then, which is, how do you prove a violation of the statute without also there being a finding then that there is not a replacement or reobligation or no intention to have a replacement or reobligation? You just told me that if there is an intent and a plan to reobligate the funds, there's no violation of the statute. But I thought you told me a few minutes ago that you didn't need that element for there to be a violation of the statute. So I'm confused.
Let me try to make my answer more precise, okay? I think there's a distinction between a replacement and a more general reobligation. So a replacement grant is really essentially the same thing as the original grant. It's a continuation. That's why the GIO has said that those grants can occur after the deadline because they're really the same grant as the original. So it's good to have an example of this. So an example is if a professor has a grant and then the grant goes to his university and the professor switches to a new university, then the agency can sort of reissue the grant to the new university as long as it's the same grant. Because the idea is that's really just a continuation of the original grant. It's not a new obligation. So that type of replacement grant, there is authority from the GAO suggesting that that could happen after a deadline, but that's an extremely narrow exception. And anything else other than that would be illegal.
So what is the effect of the repeal today? Do you agree with your friend on the other side that not even such a replacement grant could be issued today because of the repeal?
Okay, so I don't agree, but even if I'm wrong about what I'm about to say, I think in some ways it would make our argument stronger. So I'll tell you how I read this, and then I'll explain how it would work under the contrary reading. So the way I read the repealer is that the repeal of the statute has to be read in conjunction with the rescission of the unobligated balances. So like the statute is repealed as to the unobligated balances, but the obligated balances stay obligated. And so the logical way to view that is that the statute continues to apply to those obligated balances. And so and the unobligated balances are only those that were unobligated on the date the statute was enacted, which is this 19 million. And so with respect to the rest of the funds, the repealer doesn't apply. I think that's the sensible way to read the statute, in which case the repeal wouldn't matter. But let's say I'm completely wrong about that, and let's say EPA is correct, that if there was a termination, that it was just its hands were tied, it couldn't reobligate the funds at all. I think that's maybe Judge Pillard suggested in the first half of the argument, that almost strengthened the statutory argument, because it would mean that the EPA couldn't give replacement grants either, which means there's absolutely nothing that EPA could do to remedy the violation of the statute that occurred before OBBBA.
I'm a little bit confused, I think, in the same way that Judge Wilkins is, in the sense that you said it's not an element that you have to show that the money wasn't intended to be or could not be respent. Because I think that it does close the loop. I mean, if you're taking that sort of, Aiken County, the reason that was the executive purporting to be able to dispense with a congressional act or unilaterally repeal the law or whatever was because it was refusing, it was not spending and saying we are not gonna spend. And so here it's taking back or wanting to take back the money and not spend it that makes this defeat the Inflation Reduction Act, the GGRF, not just taking back the money, except so there is, I mean, to close the loop and make it actually defeating the program, you have to have something in that belt or suspenders part of it, right?
Sure. So I think that that's the sensible way to view this case, that there's this factual finding that the program was being dismantled and the court need not look further as to what might have happened.
So you can do both though, but I'm just responding to the very technical
Yeah, so on the
question that
technical,
Judge
so like,
Wilkins had, which is, isn't that a material component of the claim of the impoundment, effectively impoundment claim?
yes, as to the theory of impoundment, obviously, if there's no impoundment, then, you know, the separation of powers claim premise on the impoundment, that would go away. I agree with that. But suppose there was just hypothetically, there was a factual finding from the district court that EPA was going to reobligate these funds in some completely different way, some completely different set of
I
grantees.
know, I understand that
Yeah.
goes outside the replacement
Yes.
grants, the continuation grants,
So
and
that
so
would
that
still be-
too. So all I'm doing is trying to establish that there are different ways to close that at least, and it could be more than one, is required for the statutory
That's correct.
and the constitutional claim that you're raising.
That's all I'm trying to
Okay.
say. I mean, yeah, that's correct. I'm just trying to say that one of those things is
Yep.
necessary to close the loop.
Yep.
Yes, Ron.
So Judge Rao had asked you where in your complaint you tie your APA claim and cause of action to the termination of the Inflation Reduction Act.
Yes.
And I just want to ask you if this part of your complaint does that. This is on JA 1209, paragraph 10 of your PI motion and complaint, where you say EPA's actions are unconstitutional and violate the Administrative Procedure Act, period. Instead of executing the law as Congress passed it, EPA and its officials have impeded the flow of capital to green banks that Congress intended. And then you say defendants' actions violate the separation of powers. You say it violates the clauses of the Constitution, and it violates the executive's duty to execute Congress's laws faithfully. And then you say EPA also acted ultra vires contrary to statutory and regulatory law and arbitrarily and capriciously by pursuing unsupported claims of waste, fraud, and abuse and unlawfully terminating the award outside the regular procedures in order to carry out an executive policy of terminating the Inflation Reduction Act. Does that paragraph make the claim that there's a violation of the APA based on the statutory violation?
I agree, it makes the claim, and if I can just add one other thing to that, which is that throughout the case, our theory on the Tucker Act has been that this is, or one of our theories has been that this is a dismantlement of the whole program. So I don't think it makes sense to say that our APA claim isn't challenging the dismantlement, when at all times in this case, we
No,
said
I
that's the basis
understand
of
that, but
jurisdiction.
Judge Rao wants to
Yes,
understand where in your
the answer is yes
complaint
to
you're
your
actually
question. I think
making
the
that
paragraph that
argument.
you read, I don't have the complaint memorized, I admit, but the paragraph you read does make that allegation.
You, your friend on the other side flagged with views as sort of a potential conflict between the termination provision, which requires deobligation, and the closeout provisions. Do you have a way of reconciling those?
I don't really understand the conflict. I mean, you know, there is a provision saying that other grantees will get the funds. If the funds are reobligated, it's going to go to other grantees. But here, EPA is terminating the entire program at the same time. And so, I mean, as I read, again, we don't want to go to closeout. You know, we've said that we've argued for affirmance of the injunction. But if in fact that's where the court goes, then yes, I don't think EPA has a very strong argument that it can sweep the money back. I think that's just the plain text.
I'm just asking as, sorry, and I know I'm not trying to do contracts here, but do you have us understanding of how those two provisions in the contract work
So
together? Is a termination language narrowed or something? Assuming, because it was obviously at a time when you assume there's still going to be a statute.
I'd want to think a little more about it, but my understanding of the way this works is that if one grantee is terminated, then the funds are potentially reobligated to other grantees. But if they're all terminated at the same time, then that goes away. I mean,
They couldn't find a new grantee.
well, that's not contemplated by these agreements. I think if the whole program is terminated, then the reobligation to the other grantees just goes away because there is no other grantee to obligate it to.
I think it says not reobligate, but deobligate uncommitted funds and then reobligate them. So they deobligate, well, first of all, what is uncommitted funds?
I'd
Oh, no, okay.
want to think about these answers a little bit more and
Okay.
brief these issues.
That's fair.
My colleague,
Just-
have additional questions?
Just
Yes.
one,
So you've invoked the APA as the basis for your constitutional claim, but you've primarily relied on an implied clause of action for equitable relief. I'm just curious about that strategy and whether or not we can address your constitutional claim just through the APA.
So I think the court can address the claim through the APA. I mean, the APA permits the court to enjoin illegal federal action that's contrary to law. Law includes constitutional law. If the court concludes that there isn't jurisdiction under the APA, which obviously we don't agree with that, then I think the court could separately consider an implied action that the government has taken action in violation of the Constitution. That's really not the way I'd suggest the court resolve the case. I think the court should just say that there is jurisdiction under the APA, including to consider a constitutional violation.
and just tying up a loose end to that loose end on Dalton and your theory that this is dismantlement is reviewable because it is a constitutional claim. In order to rule in your favor on that ground, would we have to create a circuit split with the Fourth Circuit on Sustainability Institute, or can you distinguish that case?
I think that it is distinguishable. I mean, I don't view the facts of sustainability incident as analogous to this when there's an entire statutory subsection that's being terminated. I don't think that was the facts of the sustainability case. I mean, here we're citing these like provisions of the GGRF, not just like isolated programs, but statutory programs. You'll see 7434 A2 and A3 are just these full-fledged statutory programs that are being shut down.
So maybe that's bleeding into my second and last question, which is, can you help us think about the line between statutory violations that don't become constitutional claims through the take care clause or the vesting clause or whatever, and those that do?
Sure. So
because everyone agrees there has to be some line.
there definitely has to be some line.
Okay, so what do you think it is?
So I think there's really two characteristics of EPA's action that establish that this is really a separation of powers violation and not just a mere statutory violation. So I guess the first thing is the dismantlement of a program for which Congress has appropriated funds. When Congress has the power of the purse, and there's cases such as Kendall that say that it's a constitutional violation, a separation of powers violation, not just a pure statutory violation. When EPA or when the federal government refuses to spend money that Congress has appropriated and directed to spend money. And so, the full dismantlement of a congressionally authorized and funded program, I think, is different from a mere dispute over how far a statute reaches. And I guess the second aspect of this case I would highlight is just the total absence of statutory authority to undo and redo the program, because the GGRF, it just says the grants will be made before September 24. And as to undoing and redoing the program afterwards, there's no dispute, nothing even arguably in the statute allows the undoing and restarting.
So very colloquially, the line is how big is the violation and how obvious is the violation?
Well, that's true for the second part of my answer, like the absence of statutory authority versus merely debate over the scope. The first part of my answer is separate. It has to do with the dismantlement of a program that's funded by appropriations. I think that
any micro violation, any micro good faith, close call on the statute violation is going to be an Article 2 problem if it's a spending statute?
I don't think I'd say that. And I agree there's probably some area of borderline cases, but when you have these explicit statutes that are just being shut down, then I think it's far enough on the other side.
Is your distinction from Dalton in part, so Dalton is really saying any statutory violation can be repackaged as a failure to take care, right? It's the President in Dalton doesn't go through the statutorily prescribed recommendation steps before closing a base. And you could just say we violated the statute, but oh no, can't, because you can't sue the president under Franklin, under the APA. But here it's a more particular constitutional problem, which is the impoundment, the effective impoundment. And not every statutory violation can be repackaged as, an appropriation violation. It's basically, disregarding, subverting Congress's mandate that this money be spent for this purpose. It just seems to me the logic, the end run concern that Dalton raises, which is very real and is a way of enforcing Congress's power to shape and preclude judicial review in certain circumstances, doesn't apply if the constitutional defect is an appropriations-based one.
I think that's right. There was no appropriations issue in Dalton. The question was about whether the president had followed certain procedures in deciding whether to close the base. There's no doubt that the president had the authority to make the closure. It's just whether the statutory procedures were followed that were at issue. It's not as though Congress passed a statute saying that there shall be the base, and then the president just says, well, I disagree with this act of Congress, I'm shutting it down. And my attempted first answer to Judge Katsas was also, yes, the appropriations aspect of this case. There's special constitutional considerations by virtue of Congress's power of the purse that are presented when the government shuts down a program that was authorized by Congress, because the appropriations clause does say that the president can't spend money that's not authorized. And the flip side of that is that it has to spend money that was. I realize I've gone on for a very long time here.
If I may, and if you're trying to police the line between a mere ultra-virus or statutory violation or exceeding a statutory authority and a constitutional violation, is there an aspect in which that is also a factual finding by the district court? For example, dismantling a whole program seems to fall comfortably or should at least raise some issues of separation of powers if the program was authorized by Congress and the president decides he doesn't want to abide by it at all, versus a factual finding that these are individual violations of particular statutes or a particular grant. It just seems that there's a factual aspect to this, like dismantling a whole agency versus firing people. Like, I just think that there's a factual aspect in how you characterize what's going on.
So I think the cleanest and simplest way to resolve this case is to take that factual finding as a given, where it's clear error, where the clear error issue is not argued by the government. And then based on that factual record, the court can reach the conclusion that this dismantlement was occurring, and then certain legal consequences will follow from that. And the court doesn't need to really get into the close cases of when a statutory violation rises to the level of a constitutional violation, because wherever that line is, just shutting down a statute, refusing to follow a statute and shutting down a program authorized by a statute, we think it crosses that line.
Thank you, counsel. Kim.
Good morning, Your Honors, and may it please the court. Diana Kim on behalf of the state banks. I'd like to use my time to highlight two features of this case that are important to the Tucker Act issue. First, the fact that the state banks have no contract with EPA makes clear that their claims are not based on any contract. Second, the plaintiffs own the funds in their accounts and are seeking to stop EPA's interference with those funds, not an order of payment of money from the government, which means that their claims are based on a property right, not a contract right. We think that this gives the court a relatively narrow ground for affirming the injunction in this case without needing to address other questions that might arise in cases where the grants are structured differently. I welcome the court's questions.
Ms. Kim, do you have any further responses to how we should think about cases like in Reobligation at will, or the cases involving 18 USC 641?
Yes, Your Honor. We did address in Reobligation in the state bank's case, in the state bank's brief, and we agree with Mr. Unikowski's reading of that case that the court there was not saying that grants always belong to the grantor until they're expended. It says that it depends on the specific terms of the grant agreement. And the terms of this grant agreement and the purpose of the entire GGRF was that the grantees would own the funds from the outright.
That answer that Mr. Unikowski gave then similarly puts you back to the Court of Federal Claims. If the entire claim that this is a property right turns on the contracts, that is a contract claim that gets channeled to the Court of Federal Claims.
I disagree with that, Your Honor, for two reasons. First, from the perspective of the state bank's claims turn on the sub-grant agreement between the primary grantees and the state banks. EPA is not a party to that agreement, so that's not a contract with the United States for purposes of the Tucker Act. But second,
but your premise is that this is property of the primary grantees.
our claims are premised on the fact that the state bank's property is their property, the primary grantee's property is their property. But if I might get to the second question, which I think, the second answer, which I think will address your question, that was also true in Land and Megapulse. The property rights at issue there were based on a contract. In Land, the plaintiff's claim was that they owned the property, which was the shares, because they were collateral under the contract and they had paid under the contract. In Megapulse also.
There was no dispute in those cases about the property interest. And there are a number of cases that suggest grant money, whether held by grantees or by a third party, remain effectively the property of the United States. So there can be other cases about contractual property, but they don't involve grant money that has not yet been spent for its intended purpose.
I respectfully disagree that there wasn't a dispute in those cases. There was a dispute. The government and Land had argued that under the contract, we own the shares because they had been transferred outright. Similarly, in Megapulse, the government had argued that under the contract, we have a contractual right to release the money because it's not limited rights data under the contract. And in both of those cases, this court and the Supreme Court recognized that it was a property right, even though you had to resolve a contractual dispute in order to answer the property-based question.
My point, coming from the Seventh Circuit cases and some of these other criminal conversion cases, is that grants are treated differently because of the way appropriations work and grants by the United States work. That as long as there's supervision and control, which I think, I mean, I can go through lots of examples of how the government maintains supervision and control over these grant funds, even when they're at Citibank. You know, that is a unique circumstance that doesn't fit under Land or Megapulse.
So two responses to that, Your Honor. One, the mechanism of control that the EPA has over the primary grantees funds is a security interest in their accounts. And in Ickes versus Fox, the Supreme Court said that the fact that the government has a security lien is actually evidence that it is not the property owner. It is the person against whom the government has the lien that is the property owner. And second, with respect to the supervision and control, again, I would point out that the state banks are in a slightly different position because the state banks have no contract with the federal government. The federal government's relationship is with the primary grantees and the state bank's relationship is with the primary grantees. I think for those.
Your fund, I'm sorry, if you're still answering.
No, please, Your Honor.
Your funds been frozen as well?
Our funds have been frozen as well, Your Honor.
Because did you have to make accounts at Citibank or did you choose to?
We had to make our accounts at Citibank. And I would note that with respect to the freeze.
Is that part of the sub-grant agreement or? I just wasn't clear. Is that part of the sub-grant agreement or?
It's also part of our account control agreement with the primary grantees in Citibank, that our accounts are at Citibank. And that does give EPA the ability to see how we're using the funds, just as it sees how the primary grantees are using the funds. It's just not through a contractual relationship.
Government doesn't have does the government also have a security interest in?
No, Your Honor, it has no security interest in our accounts. And I think that that's relevant because for the purposes of the state banks, I would direct your honors to the Ninth Circuit's decision in Community Legal Services, where the court there found significant the fact that the subcontractors had no contract with the federal government, and that was a basis for keeping the subcontractors' claims in district court rather than sending them to the Court of Federal Claims. I would note that it is really odd that EPA wants to argue here that the state banks are bringing essentially a contractual claim, but then to turn around and go to the Court of Federal Claims and say that the state banks can't bring a contract claim there. I think that's something contradictory, and it would leave the state banks with no form of judicial review for their property-based violations.
Make sure my colleagues don't have additional questions for you. Thank you, counsel.
I'll just ask one, sorry. So if we're inclined to affirm, what's our narrowest constitutional rule? I mean, for example, are we going to say something like the executive may not dismantle a congressionally mandated program by freezing and terminating all grants on policy disagreement alone? Or is even that too narrow?
We think that that would be a sufficient constitutional holding that would affirm the full injunction below.
Thank you, counsel.
Thank you, Your Honor.
Roth, give you 4 minutes for rebuttal.
Thank you, Your Honor. I'll try to cover 3 points. One is about title, one is about the statutory claim, and one is about the impact of the repeal. So on title, which is where Kent, my friend, started, I think it's just a red herring at this stage of the case. Again, this injunction is about the terminations of the grants. That's what they sued to enjoin. That is what the district court enjoined. That means the grants were reinstated and the contractual relationships were revived. That's the injunction we appealed. It has nothing to do
Injunction
with
also
title.
prohibits you from freezing the funds.
Only, but Your Honor, only if you read the court's opinion, that flowed from the court's ruling on termination. So
I
the
don't mean
court
flowed
said,
from, it was the next paragraph, but yes.
in the order, it's a separate paragraph.
Cannot limit access to funds and accounts.
Yes,
Cannot limit
Yes.
access to funds.
right.
Full
That's the
stop.
third paragraph of the order. If you read the court's opinion justifying the order, that part is premised on the conclusion that the terminations were invalid and ineffective. So the grants are back on, therefore you cannot touch their money. So I don't mind the therefore. The problem is with the predicate about the termination of the grants. That's the part we're appealing, and we're saying the court can't do that. And I would say in response to Judge Garcia's question, the injunction is not limited to the March terminations. That's the first paragraph of the order. The second paragraph of the order says an EPA can't terminate the grants going forward unless it's consistent with various things, including the terms of the grants, which again confirms this is a contract issue ultimately, and that part of the injunction is clearly.
I thought what you had just said confirmed how I was thinking about it. What's enjoined is the predicate for the entire injunction is you cannot effectuate the March 11th termination. And the rest of it just says, and you can't do other things that would flow from that unless it's consistent with the grant agreement. So you read this to have enjoined you from terminating the case through a new agency process, terminating these contracts through a new agency process on May 11th?
Yes, I think that's the second paragraph says that. It says,
except as permitted by the ACA, the grant award.
Right.
This whole case is about setting aside agency action.
but the
That's what's
grant,
happening.
but again, the district court's basis for saying that the March termination was improper was the grant award. It's inconsistent with the terms of the grant. And so under the second paragraph of the order, we would not be able.
Well, except it's
to
permitted by the grant regulations and applicable law.
Right.
And
We have
so
to
if
be
the law
cons-
changes in a way that would allow you to do this,
Saying you do it again in a way that complies with my opinion.
I think right, but Your Honor, it's an and. So I think we would have, in order to comply with this injunction, we would have to, it would have to be justified under all of those, or put another way, we would have to show that none of those posed a barrier. And again, the district court's principal theory was the terms of the grant don't allow for termination under these circumstances. So I think to comply with the injunction, we would not be able to terminate unless we satisfy the district court's reading of the contract terms, which is a problem and is not what the court is allowed to do. That is specific performance.
did you go back, the district court also said back here, if we need to change or modify things, did the government go back to the district court after the repeal and say, look what's happened, we believe we can now do this? Let
Have
us know
not
if
gone
we're
back to
wrong."
the district court since the case has been on appeal. I do think that one of the takeaways from some of the questions here, and potentially depending on what the court does, if the problem turns out to be in this court's view that, look, terminating the contracts was inconsistent with the IRA. Well, the IRA is now gone. So I suppose we could, the day after the mandate goes back, we could terminate again based on the same grounds and say, well, there can't possibly be a statutory claim anymore. There's no statute to found it on. But I think that kind of tends to show our principal point, which is this injunction is overbroad, is not supported by the claims. And just on the statutory claim in particular, at times counsel seems to be saying that after September 2024, there could be no terminations at all without violating the statute. That I think has to be wrong. The contracts themselves contemplate termination, at least under certain circumstances. And it would be extraordinary if the government had no power after the expiration to terminate for any reason whatsoever. So I don't think that could be the theory. So it really
Why
has
would
to
that
be.
be extraordinary? One thing that strikes me about your entire case is that it acts as if the only remedies for the government have to sound in contract, where, I mean, aren't there all kinds of things the government can do? It can seek recoupment. It can, under separate statutes, it can file for misuse of funds under the False Claims Act. There are any number of things that would protect the government. So it doesn't seem extraordinary to me, actually, that there might not be. I mean, there is also in the contract a provision saying, for fraud, waste, fraud, and abuse,
Right.
which you've disavowed as happening here.
But Your
So,
Honor, if their statutory claim was correct, it wouldn't matter how much fraud, waste, and abuse we could stand up and prove. If it was after September 30th, 2024, we have to continue for 5 years in a contractual relationship with them. That
no,
can't
don't
be
you
right.
have recoupment statutory authority if a grantee violates a grant and not in accordance with its terms, you go after them?
But Your Honor, we also would terminate the grant so that we don't have to continue to engage with this person for another
I'm just
5
saying
years.
you're acting as if everything has to be packaged into the grant, and it just doesn't seem.
Maybe it doesn't, but the contract clearly contemplates termination. Termination is routine, and I've never seen any case say that after an appropriation expires, the government loses all power to terminate the grant.
When you go to if the plaintiffs refile as you believe they should in the Court of Federal Claims and say you canceled these contracts for reasons that are not authorized in the grant agreement, what's your defense?
We will argue that we were acting consistent with the contract.
And how
And
so?
Based on the argument I made earlier about the original terms and conditions being incorporated. And look, as I said earlier, we would also do discovery, and we would not be limited in that instance to the administrative record. So we might well be able to show other grounds for termination. It's not it wouldn't be an APA case. It'd be a
So you would
contract
say
case.
that you were acting consistent with the contract, that the ground to terminate because it's not consistent with policy preferences of the administration
Yeah,
is actually in the contract.
Yes, and to be clear, what's inconsistent with priorities is the oversight provisions. Okay, that's the inconsistency that we asserted would assert. And look, if we lost, we would pay the damages that the Court of Federal Claims awards. And maybe the damages would be the full amount. If they're right about title, and if we actually were able to successfully recoup that money through closeout, and then they said it was a breach of contract, we would have had $20 billion in the bank, and now we have zero. They can make that argument as a damages argument to the Court of Federal Claims. We would certainly oppose it. I don't think it's a plausible reading. And going to Judge Millett's question, if their reading was right, then again, it wouldn't matter if we were able to stand up and prove criminal conduct. They would get to keep the $20 billion, at least as a matter of contract. And that seems like that's not tenable. It also seems inconsistent with the fact that the contract contemplates a deobligation and reobligation. And by the way, the original version of the contract didn't limit reobligation to these grantees. That was added at the last minute before the inauguration, and we would reserve the right to challenge the legitimacy of that modification.
You had when you started, you said you had 3 points, and I think if you could succinctly make whatever you didn't get to make.
Yeah, sorry, Your Honor. The only last point I'll make is on the statutory claim. Since I don't think it can be a bright line rule, nothing after September 2024, it's got to be about what was EPA doing or trying to do. And that's where they get into well, they weren't really going to do replacement grants in the way that they were allowed. The right way to challenge that is to let us do the replacement grants. And if they think the replacement grants are inconsistent with federal appropriations law, they could have sued. But nobody let us get to that point. Of course, now it's too late. We can't do the replacement grants
because of the repeal.
statute is, yes. But at the time, that would have been the way to handle that problem. Not by arguing hypothetically about whether a replacement grant that we never had the chance to do is or isn't consistent with some, obscure GAO opinions that we may not even agree with.
Do we not get to that if we credit the district court's finding that you were just going to dismantle the program? We don't even get to replacement, right?
I think we do, in the sense of we get to it through at least the remedial aspect of is enjoining the notices of termination an appropriate remedy when the problem is not the termination. The problem is not reobligating the money afterwards in the way that would have been permissible under federal appropriations law, which everyone agrees there was some way to do it. We just never had the chance to actually do it.
And before you sit down, can you just, the state bank's argument, do you agree that their claims are not properly in the Court of Federal Claims? And if so, does that mean you want the grantees' claims to go to the Court of Federal Claims while the subgrantees stay in the district court?
No, so the subgrantees are not parties to a contract with EPA. So the subgrantees, unless they can show that they are intended third-party beneficiaries, would probably not have claims under the Tucker Act. That doesn't mean they can go to federal court under the APA instead. It means they're precluded from seeking relief on contractual grounds. And they cited a case from the Ninth Circuit. The Ninth Circuit subsequently in Thakur versus Trump was presented with that exact argument and granted a stay pending appeal based on our Tucker Act argument, and just yesterday denied reconsideration and on bank, nobody calling for a vote. So everyone understands when Congress limits relief in the Tucker Act, says you can't get specific performance, that doesn't mean non-parties can get specific performance through the back door. It means they can't bring contractual claims at all.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
This honorable court now stands adjourned until this afternoon at 2 p.m.